Okay, no problem. 38 tons. New matters, I think, in case of Das. So, 7 years of tolo court mention korbo lagibo. Upor hole tat korbo lagibo, senior bench. Then you can, no problem. Okay. And wait to the case diary has been.
There may be interim, my lord, interim may be
Interim is there.
continue.
Diary 39.
39.
Diary is there. Diary is also not. Case diary not received. The learned counsel pressed for an adjournment, which is allowed. Interim order shall continue till the next date of listing. List after, when do you want? Next week?
Yes.
Next week, end of next week. Is the matter next week on?
As per my instruction.
Tashish Sabit? Since he's asking. 611?
Yes.
Huh? 6.
August month.
Can you switch on the microphone, please? Thanks. Anyway, it doesn't matter. Tell me.
Lordship, I beg to mention two criminal appeal for listing, Lordship.
Criminal activity. IA or criminal activity?
Lordship.
No question.
May I please, your lordship? Lordship, I beg to mention item number 53, supplementary list. Lordship, I may be allowed to withdraw the case as a
You want to withdraw? True. Learned counsel, your good name, please. Your good name, please.
lordship. I'm appearing on behalf of A. Alom, T.R. Obang,
Learned counsel, your good name also, kindly give.
T.R. Obang,
You are appearing on behalf of
A.
A.
Alom.
Alok submits that they have instructions to.
Lordship, mandatory period is over and petitioner has already been released on bail by
Okay.
the concerned magistrate.
Infractions, with may be allowed to withdraw the petition as it has become infractious pursuant to the petitioner getting default bail.
Yes.
The prayer is allowed.
Highly obliged, lordship.
May it please your lordship. Lordship, I beg to mention item number 33, lordship. Lordship, with the consent of the other side, kindly pass over the matter for the day.
For the day,
33 case diary not received.
case diary is not received.
Custom department is there, actually.
Case diary not received.
Oh, sorry, custom.
We don't know. We have, the consent of the other side, 6 an adjournment for the day. Prayer is allowed. When should I fix it? Next week? Any
Lordship,
interim, any interim order?
Lordship, I am on interim, lordship.
Interim order stands extended till next day. List the matter on 6/11.
Lordship.
May I please your lordship? My lord, I beg to mention item 47 for adjournment. My lord, in this case, notice has not been served yet. And TCR was called for, but it
Not
has not been
received.
yet.
Submitted that neither scan record nor service report upon respondent will receive back. And 6 an adjournment, which is allowed. When should I fix it? After 2 weeks?
My lord,
After 2 weeks? So, 13/11,
My-
list on 13.
Obliged.
Right, please, your lordship. Well, there is a regular bail application, my lord, regards in connection with the custom case, my lord. And the petitioner before your lordship was arrested on 14 and last 14 days he is in custody.
Customs matter,
Customs
purely
matter.
customs matter.
Must. My lord, on 25th of, my lord, April, a team of the custom officers went to a particular Godam of Sonapur, my lord. And they met the Godown keeper, my lord, on Rabha, Ojit Rabha. And on being asked that this particular Godown belongs to whom, then the answer was given on Sharma, my lord. Ranjit Sharma. Ranjit Sharma is the owner of the godown. And thereafter they contacted with the telephone of the Ranjit Sharma, my lord, the owner of the godown, and he answered that he has rented over this godown to one particular person, namely my lord Aziz Majumdar, my lord Zakaria. And he has also disclosed, and it has been my lord Panchanama, it has been given. Then he has also said that this Zakaria, he has taken the on rent on behalf of his in the name of his wife, my lord. Actually, not wife, but their marriage agreement was taken place, and that's why it was given. And subsequently, it is also been revealed that this particular go down has been given rent, although in the name of this particular petition, my lord, but rent has been paid regularly by another person, my lord, that is Kaizul Majumdar. Kaizul Sudri. That Kaizul Sudri is the person, my lord, who has in fact taken over the position of this go down, and he used to pay the rent and all. Then subsequently some cigarettes and some poppy seeds were found. And then ultimately the rule of the petitioner is this, my lord, that this petitioner was in my lord love with the Zakaria, and subsequently, my lord, the family arrangement was taken place for marriage. Marriage was not taken place, but at that point of time, and she was taken that put a signature. I am taking a go down in your name as a first, my lord,
Yeah, very
HR. So this is
Anyway,
and Ponchnama, my lord, will find at page 11, my lord. That's all, everything, whatever I have made a submission, my lord, is available. Page 11, third para is clear, my lord. So my limited rule is this, that I have put a signature in an agreement, rent agreement, that's it. Otherwise, it was paid by as per the owner, my lord. It
in
was
a
paid
way,
by-
if this is true, then she was betrayed. And she became victim of circumstances.
My
If
lord.
this is true. Anyway, kindly you try to get the case diary a little earlier. Because if these are true, then it needs to be substantial.
And in the forwarding report also, my lord, they have
I've
14, my lord, they have arrested, and only then they have produced before the magistrate, my lord, and they have not sought for his custody also.
Her. Full stop. So all for the case diary of customs to show and so. Seizure case number 4. The petitioner was charged with violation of section 135(1) of the Customs Act and arrested under the provisions of section 104, the said act. She was arrested on 14 or 10.
14, my lord,
She
14.
was arrested on 14/10/2025, presently in judicial custody. Post of Learned Counsel appears for the Customs Department. Call for the case there expeditiously.
Short date may be given, my lord. Go
I'll
ahead.
try. When can you get it?
Your lordship, after a week, any date will be given, your lordship.
Monday, next Monday. Next Monday, or can you get it
Lordship, 7th of November.
little
possible.
earlier? Get it on Monday, because we need to see this aspect.
Yes, your lordship.
Fine.
So,
Obliged.
311, 311,
Right.
311.
May I please, your lordship? This is a POCSO matter, my lord. Notice may go, lordship.
Oh, that is
And
on 26/9. Call for the case diary of Pokrajar PS case number 223 of 25. under Friends of Federal. Accused was arrested on 26/9/25. Call for the case diary. So steps of notice upon the info respond number 2 may be taken. Step. Notice may be issued through the concerned police station. List the matter on.
On my lord, 1311.
And can it be on shorter date because petitioner is at about 64 years and is suffering from various illness, lordship.
You can put it on 10, 10,
1011.
10,
1011.
10, 11.
May I please, your
So
lordship?
is also POSCO is there.
My lord, POSCO under section 6, my lord. Child court record may be called from Golaghat, my lord.
Same,
10 November.
Dekho belega wo khali, he was arrested to position. Yeah, fair enough. This is call for the case. This is charge sheeted matter.
Yes,
Yes,
charge
right.
sheet.
Charge sheeted.
Trial is going on,
Trial is going on.
my lord.
Scan copy of the case diary, the charge sheet, medical report and deposition secretly from the court of the learned special judge Poxo Golagat. Of special Poxo case number 39 of 25. Corresponding to Numaligarh Rural PS case number 57 of 25. The accused was arrested on 5/6/2025. Steps of notice to get list the matter on, you can
On 12/11.
12/11.
Reflect.
Yeah, please, Your Lordship. Lordship, the allegation against the petitioner is Lordship 5.102 kg suspected to be ganja was recovered from the
Yeah.
possession of the accused, Lordship. And as on date, Lordship, 50 days behind the bar, Lordship.
50 days. Because 8/9. It's this, should call for the case diary of Boshishto PS case number 456 of 25. The so and so. The allegations about recovery of intermediate quantity 5.02
5.102 kg, Lordship.
kgs of suspected ganja. Full stop. The accused was arrested on 8/9/25. Call for the case diary. This is the matter on
On 4/11.
Kindly on 3, Lordship, 3. Can it deep down?
11.
This is my application, my lord. My lord, this is a case, my lord, which I will not bring it within the corner of a straight case because based on the order of this honorable court, my lord, the trials continued, but it was only one witness which was examined. And my lord, now I have come back. Now, my lord, before I just take your lordship across few pages, I want to give the backdrop of the case. My lord, the case is initially of the year 1994. It's a Tejpur police station case number 1994. Petitioner was not the prime accused. My lord, the truck was intercepted and my lord, a case was started. The seizure was done on the subsequent date, my lord, of the interception, after the driver and the handyman has fled away. Now, my lord, subsequent to that, charge sheet was submitted, but at that juncture, the learned court below was of the opinion that this is a fit case which should be handed over to the CBI for investigation. So 99 investigation was taken over by CBI. During investigation, based on the number of the truck, I was the one who had initially brought the truck. So I was brought into this matter. That is in the year 1999 was the date when this CBI case started. I was arrested 2000 and I had purchased the truck in the year 1988 and had sold it long back. It had crossed several hands. Now, my lord, I am really not on that because I tell your lordship, there was something definitely flaw on my part because after I was arrested in 2000, I was released on bail pursuant to an order passed by this honorable court. However, there was some technical error in the recording of the order, based on which, my lord, the apex court was approached by the prosecution, and the apex court actually turned down, saying that the honorable high court has not considered the entirety of the sections because one part of the section was not recorded in the order.
Right.
Now, my lord, subsequent to that, this came back, and this person, my lord, after appearing once, even thereafter, for the examination process, he left the state and he went out and was sitting in a temple and serving there for the rest of the tenure until and unless he was arrested and brought
Okay.
back again here. And my lord, that arrest took place in the year 2022 in the month of September, 28th of September. Now, my lord, there starts the entirety. Now, why I say this is my lord, when this person was brought in, there was no case record. The case record was found missing. So, my lord, whenever the matter was remanded and came back before the court below, time and again, my lord, prayer was made for being released on bail, and my lord, the case record was to be detected. It is all provided here in the order. I shall take your lordship across to the order of
The
this
case is
court.
presently at the stage of trial.
My lord, case is presently at the stage of trial without the case record. There is no case record.
It was not.
Now, my lord,
Not reconstructed, right?
my
Could
lord,
not be reconstructed.
my lord, I tell you, your lordship, the only thing, if your lordship turns to page, if your lordship kindly turns to page 38 once. Page 38.
Yes.
It's the order of this honorable court.
Hmm.
My lord, this is the crux of the scenario which is projected in this order when we came up before this court. My lord, why we came up here is that we were actually relying on Husainera Khatun, and we were saying that in the event this matter can be proceeded to a logical conclusion, let it be. If not, then I should get the benefit of quashment. My lord, that is the situation where I had come on the last occasion.
Okay.
However, my lord, this is what was, my lord, taken in. And my lord kindly turns to page 39.
Yes. I'm on
The
39.
second last paragraph, if your lordships, rather the second paragraph from the top, after in the revisional petition was extensively heard, my lord, thereafter, it is an admitted position and reflected in the order dated such and such. The case record are not traceable in the court. It is also discernible from the order dated 17/5/2023 that the original record of Tejpur police station case number such and such was returned back to the CBI officer named Mr. Chopra by the court on 29th of January 2000. However, while traveling from Guwahati to New Delhi, all the original documents collected, including from the court, was stolen on 22nd of September 2000. And charge sheet was filed on the basis of certified copies of documents made. They have been served.
CBI counsel has to be appear in this case, my lord.
CBI counsel will appear. CBI says it is, the prosecution is now CBI.
Yes, my lord. Name also has not been shown in the.
Not been
CBI
shown.
counsel in the court.
My lord, let me just give the backdrop of the case, my lord.
Yes, yes.
Perhaps, my lord, this is something where CBI has very little to say. It is your lordship who has to take the call. My lord, prima facie, the aforesaid facts in the history of the case shows that the delay in the prosecution cannot be solely attributed to the petitioner, and this case discloses a very disturbing situation wherein a trial has been pending since last 23 years, and admittedly there was no original record of the prosecution, and there is also no court record, and supplementary record was created in the year 2022. Now, my lord, this is where it is. There was also.
Just tell me
my
two
lord-
things, madam. One is that now trial, what is the?
My lord, there are 51 witnesses.
51, just a minute. 51 witnesses.
My lord, before
Out
this
of which-
person actually left the state and went to Bihar, my lord, it was two and a half witnesses who were examined.
So far, that is.
CBI, yes, CBI said that it was 12. Now, my lord,
Okay, anyway, 10, 11.
no 299 was involved, my lord, kindly cease.
And then.
But now, my
he's in
lord,
custody since.
my lord, now after being taken since, my lord, 2022, September 28th, he is in custody till date. Now, my lord, the only thing, two things I just want to show, my lord, that is, my lord, it is said that there were few witnesses who were examined. I take their word. My lord kindly turns to this page. This is the recording, the only deposition which could take place, and this is the person who had been present at the time of interception. That's page 92. I have annexed.
And the quantity is intermediate quantity, I think. Not, it's commercial quantity.
Commercial. My lord, there is no
Prima facie commercial.
prima facie.
Anyway, so this is the.
My lord,
page
kindly-
92.
92 is the only witness. This is the person who was there and at the time of interception of the vehicle in the year 1996. 1994, sorry, my lord. 9/4/1994, he was the person who was there to intercept the truck. My lord, it is also his statement. He is the person who is rather the prime witness, and he says that he cannot even identify the petitioner before your lordship. So that is one set of it. And now, my lord,
How are they proceeding, if there is absolutely no record? You know,
and my lord, kindly
because,
see,
the record, something has to be reconstructed at least, isn't it?
should be, but that has not been done.
Let us-
Kindly sees, my lord, the deposition says PW1. So if there is already evidence is already there on record, how can it be again from one? I'm asking to myself. And my lord, this was the case diary I just want to give because I had this was a supplementary case record. This is all that is there before the court below, and this is what is the basis based on which evidence is being
Should I
adduced.
keep it now or after we, you know?
My lord, your lordship may keep it, or we can give it just for a glance. Your lordship may take a cursory view,
Yeah.
and we shall make one and come back because I think it will take a bit more time of your lordship.
Yeah.
So this is the thing which is there, and this is actually the thing. This is how it has been given.
Yes, yes, certainly, you know, it may be useful on, I'll take it on next day when
I shall give.
they come. Now you keep it.
Maybe come back then
It's-
after some time so that
The CBI
it will-
counsel, yeah.
CBI.
Let us-
Well, if it otherwise your diary permits your lordship, then can I come back on 21st of November?
Yeah, why not?
Because in any event, I cannot say that I am in a hurry because it has to come to a
There's
conclusion now.
checkered history, and interestingly, you know, I remember, I think there's a reported judgment of this, you know, some connected matter of this. When you said reconstructed, the record was reconstructed, it was lost, then I
I
recollected.
had
I've read
submitted,
it.
I had
don't remember
submitted,
full facts.
I shall show
Hansing
from
the-
that order.
Hansing the truck driver. Truck driver.
Yes, that reconstruction also has to go by a process.
It is a reported judgment is there. It's pertaining to one of the petitions filed by the petitioner. Anyway, now we'll definitely look into the question of bail. So at this stage, your good name, please, ma'am.
Shutapa Shanlal.
Learned counsel appearing for the petitioner. Full stop. It appears that the present, the case out of which the present bail application has arisen has had a checkered history. And the case is presently stated to be at the stage of trial. Full stop. The case was investigated subsequently by the CBI. The name of the standing counsel or retainer counsel, standing counsel CBI shall be shown in the cause list. I think Mrs. M. Kumari will appear. Yes. She's retainer counsel, she will appear. So we can also call. for
My
the-
lord, I was told by my advocate on record that already she was served. But however, she is not there, a fresh notice will be
It's not
effective.
shown, on the PP Assam is shown. So her name will be shown,
Whatever,
right?
it is, my lord, he shall do the needful
All for
because
the-
I'm not that.
Call for the
Conversant.
scanned case diary, charge sheet, depositions and other relevant portions of CR case number 6 of 1996 arising out of GR 413 of 1994 corresponding to Tezpur PS case number 211 of 94 corresponding to CBI case on the court of the learned special judge Sunitpur Tezpur. The reference of the CBI cases, RC number 6 of 99. Full stop.
My lord, I had an innocuous prayer.
Yeah.
Provided it is otherwise not
No, but-
embarrassing to your lordship.
No.
But since I have made a protracted submission, if it suits your lordship to keep it at Pathat, because I think next day it will be over the moment CBI comes
I
in.
think, with all respect to you, I mean, at this stage, I think it's not necessary because there's just we are calling for the record, you know. on substantive matters, you have just introduced the
My,
facts, right?
as it's
Let
possible.
it be like that.
My lord, on 21st.
And council, anyway, we'll fix it like that. Call for the state to list the matter on 21/11/2020. By this time, we have also called for the record, so it will be advanced.
Much obliged.
Here, my lord, with all respect, my lord, the report was sought for, my lord. And today regarding,
49.
regarding the quantum of detention, my lord, these are all 60-day period offences, my lord, although extend to 10 years by Assam amendment, my lord. Here, my lord, with all respect, 30 days already inside, so far as quantum is concerned. And so far as the law,
My lord, report, my lord, we have not received. Actually, my lord, I was on leave, my lord. He has sent a letter.
This was the case of, you said, no one sadhu or something.
my lord, kindly see, it's not like a rhino poaching or tiger poaching, my lord. That is, since generations it is at my place. And now what they have done, after your lordship's order, they have woken up and they have served the notice on the wife on 24th, so that they can say that investigation is continuing. Can I just place it before your lordships, my lord? This is possibly not done, my lord, with all respect. And if that can be done, without IO also, which is, my lord, so far as a police manual is concerned, of course, it is forest case, triplicate case that is to be maintained, my lord.
Forest case.
Exactly, my lord.
Triplicate.
Exactly, my lord. And this is the ACF, my lord, who has served this notice. So, my lord, they cannot eat the cake and have it too, my lord. One way they continue the investigation, and before court they say that the IO is on leave. That is possibly not done, my lord, and 30 days inside, my lord.
When can you get it?
My lord, actually,
Speedily.
uh,
Let us decide the issue, isn't it?
on Friday, my lord, positively.
My lord, that would,
Because, my lord, this is the,
huh?
Thursday, maybe. Thursday.
What delay part they cannot develop, my lord, with all respect, my lord, that's a constitutional matter. my
no
lord.
question of development, my lord.
No. What I am saying, my lord, by note or anything, they cannot develop. Can it be tomorrow? I should not say.
Tomorrow, my lord,
Day after tomorrow, my lord.
If they are, if they
Yeah,
can
we'll not-
bring
ACF can send it, my lord, because the
Yeah, my lord,
person who has
your
served the
lordship agree,
notice.
my lord, on Thursday, my lord. On Thursday, my lord.
I'll get it on Thursday.
My lord, I will collect.
My
Report as called for, it's not yet received. Let's stop. Issue phrase requisitions for the same.
Yeah.
The learned standing council, Mr. Sharma, learned special people, wildlife crimes, Mr. B. Sharma. Submit that he will procure the case diary. He shall try to procure the case diary by Thursday. This is the matter on Thursday will be 31st.
Thursday, my lord.
30,
30, my lord, 30.
30/11, 30/10, sorry.
10.
My lord, can get notice dated 24 be kept as part of the record, my lord.
Yes, sir.
My lord.
Yes, public.
May I plead the lordship, my lord, this is a 483 application, my lord.
Yes.
The petitioner is in custody for last about 40 days, my lord.
Yes.
The FIR is at page, my lord, 9, my lord. Relevant portion starts at page 11, my lord. Regarding, my lord, cryptocurrency, the petitioner,
Cryptocurrency.
yes, my lord. So the CD may be called for and a short date may be given because already he has he is in custody for last about 40 days, my lord. He created a user ID and was doing some transaction, my lord. Apparently it is not illegal, my lord. Anybody can create and they can do trading or
Cryptocurrency has its own controversies, right? I mean.
yes, my lord. Yes, my lord.
Well versed with, but still
Yes,
have a broad idea.
yes.
Anyway, VP Bora, Learned Council. Call for case diary of Lakhimpur, PS case number 132 of the 25. So section, the accused was arrested on 18/9/2025. List on, can we fix it on 3rd, 1 week later?
Yes.
Lakhimpur would be in Kasar.
No, Gwalpara, my lord.
or Golpara Lakshmi.
Goalpara.
It's on 311.
Obliged, my lord.
CLE যাব ন? CLE যাব। সুবিধা হয় মানে।
May I please, your lordship, the anticipated bail application, lordship, such seated lordship petitioner was such seat is submitted against the petitioner as absconder, lordship. Lordship,
I
right,
think, 21C is there,
Yes,
we'll need the
21C.
record.
lordship, NBW was also issued against the petitioner, lordship.
From, it is in which court? Dimasa.
Demands of lordship.
Stop. The petitioner is seeking pre-arrest bail with regard to NDPS case number 11 of 25, pending before the court of the learned special judge Dima Asa Hoplong. The case arose out of Harangazao, yes, case number 20 of 24, under 21C 29 NDPS Act. The case has been charged sheet. A trial has started.
At least it's started.
And is at the stage of trial. And there is a pending NBWA against the petitioner. So, call for the scanned record of the case diary, charge sheet, and depositions, if any, of NDPS case number 11 of 25. Police case to likhi, Haranga Jao, yes, case 20 of 20. Please the matter on. Can suggest
1611,
Lordship, can it be on before 15, because next date is 15 on 11, please.
on 1411.
will it, because Margie keep a little, yeah, will it be possible,
On 10th,
no, no, just let me, I'm just saying. The next date is
on 15/11/2025.
11. Can it be on 10/11?
1011, yes.
Which one? 10?
10.
10.
10.
First of
10/11.
Lordship.
May it please your lordship, the anticipatory bail application. Lordship is aware of the digital arrest scam, my lord, where people get video calls in which they are asked, they are said that they are put on digital arrest and they are demanded money.
Mhm.
This is a similar case, my lord, where the informant was allegedly made to pay a sum of 56 lakhs.
56
By being told that he was put under digital arrest and that NSA had been invoked against him. Now, the petitioner before your lordship, on the basis of this FIR, the two main accused persons were arrested, Manoj Deka and Himanshu. Now, this petitioner before your lordship, he had withdrawn money from the account of Manas, my lord, and that is why he has been implicated in the case. But perhaps, my lord, considering the overall gravity of the case, perhaps your lordship would like to call for the case diary.
Is there? Fair enough. West Nawaz, Learned Council.
The only prayer, my lord, perhaps a shorter date, my lord.
Call. Call for the case diary of Musalpur PS case number 47/25. Stop. And so, list the matter on. Give it
On my lord, 1211,
next, previous week.
711.
This
Yes,
is
my
okay,
lord.
or you want?
No,
Seven.
711.
7.
I'm deeply obliged.
May it please your lordship. My lord, here, my lord, is the second application, my lord. At this stage, I pray, my lord, the case diary along with the postmortem report, my lord, when it was considered, postmortem report was not there. Postmortem report was maybe called for, my lord.
Semapullah, Learned Council, who fairly submits that this is a subsequent petition and at this stage case diary along with PM report, which was earlier not available, may be called for. Allowing their prayer, call for Juria PS case number 205/25. So along with PM report. List the matter on.
Junior.
On my lord, 1111, my lord.
I'm deeply obliged, my lord.
Yeah, please, Lordship.
Yeah.
May I please, 42 application, Lordship. Allegation section
281, 105 of BNS, Schedule Section 184 M Motor Vehicle Act. The accident case, Your Lordship.
Accident case,
Accident. FI is page number 11.
culpable homicide, action has been launched.
Yes, 105 is also there.
FIR is there.
Page number 11. Type long FI, Your Lordship.
CCTV footage is also there. Heard Archie 3. A call for the case diary of Borhola PS case number 48/25 under section so and so 281 of /105 of BNS. Read with 184 of Motor Vehicles Act. List the matter on.
Your Lordship, protection will be granted. He will give a statement here before the IO.
My lord,
Very inclined because
on 311, start date. 311,
311.
311.
Yes.
May I please your lordship? On a free arrest bail application, my lord. Two petitioners are before your lordship, my lord. They are both husband and wife, my lord. In this case, my lord, two of the named accused, they have been arrested. This petitioner also, my lord, they have been named in the affair. And my lord, the one application, my lord, BA 3435 is fixed on 311, my lord.
Okay. 311. We can fix the same on
Later
311.
relating, my lord, excise act, some excise act.
Mahendra Gogoi, this one's-
Only, my lord, may I pray for the, my lord, interim relief for the, my lord, lady, my lord, who is a, my lord, patient of epilepsy, my lord.
Heard the PM Chaudhary and P. Bhattakur additional PP. The instant bail application has been filed under 482 BNSS, seeking pre-arrest bail for the two petitioners stated to be husband and wife in connection with Titabor PS case number 155/25 under section so and so. The gist of the allegations in the FIR is about
Manufacturing of Sulai model.
manufacturing of country liquor / Sulai from their premises. The learned counsel fairly submits that both the petitioners are named in the FIR. But seeks some interim protection for the petitioner number 2, who is stated to be a patient of epilepsy and wife of petitioner number 1. Call for the case diary from the concerned police station. Allowing the said prayer, it is directed that in the interim, in the event of arrest of petitioner number 2, Remjin Gogoi, in connection with this case, allowed to go on bail of 20,000 with 108 to the satisfaction of the arresting authority, and subject to the condition that he shall cooperate with the investigation and make herself available for examination by the IO. So, list the matter on which date you are giving?
On 311.
311. Okay, 311.
Along with, my lord, BA
Okay, list the
3435,
matter on 311 along with BA number.
3435 or 2025. I am obliged, lordship.
May it please your lordship. Lordship, the petitioner here is seeking quashing of an FIR dated 3/11/2023, which has been charge sheeted, your lordship. The FIR is at page number 10 to 11.
So you have to upgrade your prayer, don't you think so? Because you will need
Yes, Lord.
washing of the charge sheet also now,
Yes,
right?
Lord.
So maybe you can file an additional affidavit to bring it up to date,
Yes, Lord.
isn't it?
Lordship, similarly, a trial court records call for and it is in seal before your lordship.
It's received. Doimari, Mr.
Yes,
Doimari, N.J. Doimari. At the time of filing this criminal petition, the petitioner was seeking quashing of the FIR pertaining to Koliabor PS case
No,
number
not-
97 of 2023. However, it is submitted that in the meantime, charge sheet has
No,
also
Lordship,
been submitted.
charge sheet has already been submitted earlier. Even the charge sheet is added here, Lordship.
It is already.
Yes,
added.
Lordship.
You're seeking quashing of the FIR.
Charge sheet and FIR as well.
Seeking, FIR of this thing. And the and the resulting charge sheet pursuant to investigation.
What is on record, Your Lordship?
Was on record. Scanned case record as called for has been received. The respondent has been served. Respondent. Let us check. Krishna Gogoi has he been
Yes,
served? He's been served.
The respondent was one of the police officers of the Koliabor police station.
Then you can represent perhaps.
Yes, Lordship.
Gotago.
Yes, well, I can represent.
No, it's already there. The additional, learned additional PP is also representing the respondent who is a police officer. And that is reflected in the previous order dated 11/8/2025. In the meantime, the scan case record has also been received. So we should, what to do? Should I admit it and then, or you want a disposal?
Yes, Lordship. If Your Lordship may please.
But we'll have to go inside now then.
Your Lordship may admit to them. Your Lordship may admit it.
Or we can keep it at the admission on a hearing day.
Okay.
Or
Yes,
another
but
option
that-
is that
that-
if the time permits, it may permit today. We can take up in the second half.
Okay.
That will be better.
Your
Time-
Lordship may fix it some other day on the hearing day.
Lordship, it may be fixed after 2.
After 2,
Yes, today.
you will have difficulty. No, it's okay. I'll not force anyone.
Yeah,
We
it
can
will-
just keep it open. I'll not force,
Yes,
don't worry.
yes.
I never. So if time permits, it may be possible. We'll take it. Otherwise, we'll fix it another day on a hearing day.
Oblige.
এনেকে যাওঁ চিৰিয়েলি যাওঁ
May please, Your Lordship.
12 may kindly taken up after some time, man. Yes, yes, ma'am.
Can I take it?
My lord.
Will it, the,
Second half. No. Disposal triggering the second half. Yes,
yes, Millard, I appear for the petitioner.
yes.
Millard, the allegation against the petitioner is under sections 22C of the NDPS Act, Millard. Millard, the allegation in a nutshell is that, Millard, the petitioner, the complainant, Millard, the complainant was carrying out luggage checking duty at Guwahati railway station, Millard. Millard, during the complainant is a ASI of police, Millard, of the GRP, Millard. Millard, while she was carrying out this luggage checking duty, Millard, she got onto a particular train, Millard, that is 12516 down Shilchar Coimbatore Express. She was checking the baggages of the passengers. Millard, the petitioner, who was allegedly sitting at seat number 63, Millard, the complainant under suspicion checked his bag. And Millard, allegedly 10,000 tablets of yaba was recovered, Millard. Now on the last occasion, Millard, when this application was taken up, Millard, for hearing, Millard, the Honorable Court was pleased to ask me to satisfy the court as to whether the grounds of arrest, Millard, had been communicated, Millard, to the petitioner, Millard. As per the memo of arrest, Millard, which is annexed at page 16 of my application, Millard, the name of the relative, which is column number 5, Millard,
Just, what is the page number?
Millard, page 16 of my application, Millard, the main application.
Arrest memo.
Yes, Millard, column number 5, Millard, if my, Millard, out there it is stated a WT message sent, Millard. On the basis of this, Millard, I was,
15 notices there. it must be 15 notice na, at that time.
Yes, my lord. My lord, now,
Or BNSS had already come.
my lord, BNSS had called it down because this is a 2024 March.
BNSS had, no, BNSS had.
No, section 50, my lord. Section 50 is applicable.
Notice is there, mark it.
Is there?
Now, my lord, I was asked whether the grounds of arrest were communicated to his relatives, my lord. My lord, in support of that contention, my lord, I filed an additional affidavit, my lord, which is on record with my lords. My lord, this WT message, my lord,
Well, if it is in proper format and if it is served,
my lord, it
There
was
is no
not
problem.
served. It was not served.
that is not only a problem, but it has to be served.
My lord, it was not served. It was sent to the,
Jurisdictional police.
yes,
Police station.
to this OC, the officer in charge of Sahibganj Police Station at Coach Bihar, my lord. My lord, charge sheet has been submitted, my lord. Charge has been framed in the month of September 2024, my lord.
Trial is going on.
No, my lord. My lord, till date, only one witness has been examined, my lord. My lord, I'm in custody for more than 1 year, 7 months, my lord. And my lord, as far as the seizure is concerned, my lord is well aware, my lord, that my lord, ASI, my lord, is not a gazetted officer, my lord. My lord, that an ASI cannot make such seizure. The ASI, the complainant, my lord, had ample opportunity to call for a gazetted officer at the time of seizure, my lord. That was not done. And my lord, this entire seizure has taken place at Guwahati railway station platform, my lord. My lord, there is no, my lord, as per the charge sheet, my lord, the list of documents, my lord, there is not a single document to show that there was a railway ticket, my lord, or even a platform ticket, as a matter of fact. So, my lord, it is very doubtful, my lord, this seizure. And my lord, as far as the trial is concerned, my lord, there is absolutely no progress. My lord, for my satisfaction, my lord, kindly peruses the charge sheet once, my lord, particularly page 18, my
I
lord.
will. Just a minute. I'm just seeing the wireless misses. Charge sheet at page.
My lord, page 17, my lord. Page 17 of the bail application, my lord. My lord, kindly comes to page 18, my lord, where the description of the seized property is there, my lord. My lord, it only speaks of the contraband, my lord. My lord, that's it. My lord, it continues on to page 19, my lord, and a mobile phone and a backpack. My lord, how can a person travel without a ticket? And even if he did not travel, my lord, if I take the prosecution's case to be the gospel truth, my lord, even if he's inside the platform, my lord, he should have at least been in possession of a platform ticket, my lord. My lord, neither have they seized the CCTV footage. My lord, neither has there been any videography, my lord, which is mandatory, my lord. And the entire process of search and seize are done by a non-gazetted officer.
Anyway, so the scan record has been received.
Scan copy.
Okay, let us see the notice.
My lord, section 50 notice is there, my
Secondly,
lord, ground of
50 notice, since he has made the contention, in any case also we should see it.
My lord.
But 50 notice and 50,
Yeah.
50A notice,
My
let us see, right? And wireless is not a problem if it is served and if
My
it is
lord.
in proper format.
My lord.
If it is not, then it's a
My
problem.
lord.
Then it will be difficult. What is your instruction? Was the wireless WT
lord,
message
that is-
served upon the family?
My lord, that
No.
instruction I don't have, my lord.
Don't-
have, my lord.
But any case, this has become secondary actually, because
lord.
this 50 notice will not suffice.
My
This 50 notice will not suffice. Because at that time it was like this only,
My lord,
short notice.
my lord.
In that case, he may be entitled to bail. Your good name, please?
Lordship Prajnadipta Roy.
The instant application has been filed under 483 BNS seeking bail for the accused Ali Sahib, who is stated to be in custody since 21/3/24 in connection with Guwahati GRPS case number 78 of 24 under section 22C of the NDPS Act. You can have a seat, please. You can sit down. 22 of the NDPS Act. It'll take 5 to 7 minutes. The allegation in the FIR was that on 23, this team, 24, in the early hours, some police personnel of Guwahati GRPS conducted checking of luggage of passengers in coach number B4 of 12516 down Silchar Coimbatore Express, platform number 4 of Guwahati railway station. And while checking one bag of the petitioner, he became nervous, and secondly, subsequently he was brought down from the train, and upon opening the bag, 50 numbers of blue colored plastic packets containing 200 numbers of suspected Yaba tablets, Yaba to capsule tablets each, was found, totaling about 10,000 tablets. The aforesaid suspected psychotropic substances stated to be falling in the bracket of commercial quantity. Full stop. The investigation resulted in a charge sheet and the case. What is the case number you've given? Special NDPS case is stated to be at the stage of trial before the court of the learned special judge at Kamrup Metro. The petitioner's counsel submits that an additional affidavit has been filed to bring on record a WT message of notice of arrest, which was sent to the concerned police station to be served upon the relative of the accused. The scanned case record is available. Heard G. Chutia, learned additional PP for the state. From the record, I have perused the section 50 notice, which reads as follows. The learned additional PP also fairly submits that he does not have instruction as to whether the WT message upon the family member was served upon them. Nevertheless, the WT message is also bereft of other details apart from informing that the petitioner has been arrested in connection with the mentioned case. The aforesaid nature of the notices under 50/50A CRPC as it existed then would not meet the standards laid down by the Honorable Supreme Court in the case of Purkastra and Bihan Kumar, so as to fulfill the mandate of Article 22 within bracket 1 of the Constitution of India. Full stop. In those judgments, it has not been held that the principles laid down therein would be applicable only prospectively and not retrospectively. And therefore, although the LS Caesar was made in March 2024, but the principles laid down in the judgments would be applicable. Stop. The present case being one pertaining to alleged commercial quantity of psychotropic substances under the NDPS Act. The rigors of section 37 would be applicable. However, it has been held in Purkastra and Bihan Kumar that if the accused is found entitled to bail on the basis of procedural infirmity in the arrest documents, such right would prevail over statutory bar on bail. Accordingly, in the given facts and circumstances, the question of determination of section 37 becomes academic, as due to the procedural infirmity at the time of arrest in the two notices, the present petitioner is found to be entitled to bail. Accordingly, the petitioner so-and-so is hereby allowed to go on bail of rupees 75,000 with one surety of the like amount, the satisfaction of the concerned learned court, and subject to the conditions that he shall be available for the remaining trial. Number two, he shall not hamper or tamper with evidence. He shall not try to influence witnesses. He shall not misuse his liberty to commit any illegal activities, including any activities prohibited by the NDPS Act. Through additional session judge number 5, Kamrup Metro. Additional session judge number 5. Bail petition stands allowed and disposed of in the aforesaid.
Grateful,
case.
Obliged.
Please, your lordship. Lordship, in this matter, your lordship, notice was issued. One learned counsel has also filed vocal.
Poxo matter.
Your lordship,
Yeah.
his behalf.
It appears that the scan TCR has not yet been received, though learned counsel R. Rongmei has entered appearance on behalf of respond number 2. Stop. Issue reminder for the scan TCR. From its Kamrup Metro. Stop. Please the metro. This can also be on 6th. 6th or 7th?
7.
7.
7.
Lordship, my senior is out of station. Kindly adjourn the matter for a day.
Not today.
Lordship has granted bail to the co-accused of this instant case, Lordship. Already 3 accused are granted bail by this honorable court, Lordship.
On procedure,
Yes, Lordship. On notice, Lordship. 47 notice, Lordship. I have
Yeah.
any,
have you filed you wanted to file an objection? Have you
Not
filed?
No, till now, we have not filed an objection, Lordship. Allow us 2-3 days time.
Are the notices available here?
Lordship, I have annexed, Lordship. And Lordship, I have the bail orders also, Lordship. Lordship had granted that.
All right, when can I fix it? 2 days?
After 2-3 days.
After 2 later. But you give me that order. You brought the order.
Yes, Lordship.
I'll keep it here. Huh? Keep it here. Give me one order, that will suffice. Current counsel appearing for the NCB submits that semi counsel Mr. Kyle is on outstation.
Out of station.
Is outstation. And seek some time for the same, as well as to file the written objection if in prayer is allowed. So this case. Is the matter on, when should I fix it? On 31st?
Lordship,
31st?
31st.
3110. So 3110.
Highly obliged.
Yep, yep.
May please your lordship. Regular bail petition, my lord, as on today, 125 days, my lord. Charge sheet has been submitted. FIR is at page number 14, my lord. And notice has been served and TCR also called for, my lord, that is maybe available, my lord.
Receipt. You have appeared for the informant.
Time for the informant.
So we can dispose of it. It is avoidable. Okay, where should I go?
14, my lord.
Page 14.
vernacular is the page number 60, my lord.
He's in custody since?
She was custody since, my lord, 25/6/2025, my lord. And as on today, 125 days, my lord.
Charge sheet has been submitted.
Yes, my lord, charge sheet.
Trial is not started.
Now in appearance stage, my lord, because there are two accused. One is the petitioner and other is still, my lord, absconding, and PNA is issued, my lord.
Yes.
And
Prosecutor.
My lord, a statement of the victim guard was there, my lord. And the medical report is also there, my lord. That, and the medical report reveals that she was pregnant.
For some time.
Yes.
And
And call for the report again.
Both are awaited.
Record again. And that's why was not, then last order, my lord, order the 1710. So why the learned court will now not furnish the TCR, my lord?
It's
Time
from-
extraordinary is to be called for. Now in Los Angeles, although call for, but all original certificate with us, my lord. That record is also perhaps not necessary. Now, so as the environment two is concerned, 3 times we have taken steps, and I got information that they will appear in the court below on PW. The information was examined on 25/9/2025. He knew about the case. They are not intentionally not appeared before this noble court. Philosophically, this he was examined, man. Environment one, he was examined on 25/9.
Victim has been examined.
The victim, death fix has not come. I got my tumor has been, death is fixed.
It's for victim.
Yes, for victim.
Good
So
for-
127 days I am in, and all the other records, all are allowed to go on bail by the land court below. They are also absconding. Those persons were allowed to go on bail. These 3 persons, ladies, he has a minor daughter, children, they are not allowed to go on bail by law. There are altogether 7 accused persons. 4 persons are allowed to go on bail very recently.
In this case.
No, my lord, 120,
Only for
127 days.
tomorrow. Victim is, you take instructions, issue reminder.
So
for the-
tomorrow is the date fixed for evidence of the victim.
It's good. If it is examined, it will be good. Then you can take the instructions also.
Well, if there is
Prosecution
information
can
not,
also, you can also take that instruction also, whether she was examined tomorrow, it speaks tomorrow, no? In the meantime, if she is examined.
what that my
good for
faculty
it.
given.
The learned counsel for the, J. Ahmed, Mr. Counsel, learned counsel for the petitioner. Submits that the case is awaiting the receipt of scan TCR and notice upon informant. Issue reminder for the scan TCR. The prosecution shall take instructions regarding the service of notice as well as regarding examination of the victim, which is stated to be fixed tomorrow.
Yes. Alora, if the next day scan will not come, madam, it can be disposed of on the
Just,
basis of record available here, madam.
Certified copies are there. If the
Yes,
victim
yes.
examination instruction comes and the informant notice is there, then we can perhaps proceed, right?
On 7/11.
We want some authenticated copies,
Yes, yes.
not necessarily of the record. This
Yes,
is, we have to be realistic.
My lord.
Take this back.
Short date mein gali huli.
7/11.
7?
7/11.
Wait, please, your lordship. Lordship, this is a regular bail. Last occasion, lordship, there was a direction to my learned friend to get
Got
any
instructions.
Yes, lordship.
Yes, here. Charge sheet submitted, lordship.
She submitted, but lordship, 66 days, lordship. The FIR lordship will find on page 14, lordship. Isn't in between, there's a sister-in-law and brother-in-law, lordship.
So anyway, regarding the informant, have you
That part is not here, lordship. We have not received.
returnable by? Notice has been issued.
Notice
Yes,
is issued, but whether they have received or not, that is not.
FIR on page 14, lordship. Can peruse that FIR, lordship.
Sub-
We have
sub-
concealed that matter.
Charge sheet submitted on 27/9/25.
27. And the ground of arrest, Lordship, on page 19, Lordship. Lordship, regarding, sorry, Lordship, requirement of police remand that was reflected in page 19, Lordship. 3-day custody was given to this police, Lordship, to interrogate this petitioner only because it's to ascertain the address, Lordship.
This submitted by the learned additional PP, DP Goswami, that instruction has been received that in the meantime, the case has been charged sheeted upon completion of investigation. The case diary, however, is not yet received, nor the service report with regard to service upon the upon the informant. Can you will take instructions regarding the informant?
Lord, then we have to take instruction.
What do you
whether
suggest?
They have service completed or not.
And charge sheet copy shall we get?
Charge sheet copy, only the number you have received from the concerned Lordship, police station Lordship.
Take some time then.
Yes, charge sheet number 32125 only. And they have said the final form along with the 11 documents have already been sent to the honorable court.
Issue reminder for the scanned copy of the case diary along with the charge sheet
Lordship.
filed in the meantime. The prosecution shall take instructions regarding service upon the informant. And when should we fix it? 6?
6, 7 or 6, we have
6 or 7?
7.
Can it be on 6, Lord?
6.
I leave this.
21.
May please, Lordship. My lord, may kindly see the FIR, page 9A. Here, my lord, father, uncle, and son were implicated. Thereafter, the case of the father and uncle have been segregated. And then, only this petitioner Gopal Sutradhar is before your lordship now. Now, my lord, there is allegation that
Lordship, scan copy not received.
Not received. Counsel is also not busy. So now he may be busy. Current counsel for the NCB submits that scan copy as called for is not yet received. Issue reminder for the same. Is the matter on? It is at the stage of trial.
Yes, Lordship.
Scan copies of case diary, charge sheet, and depositions. Issue reminder for the same. Please the matter on. He is not here, so to 611.
Lordship. Highly obliged.
Okay, it's right. See. Case diary, charge sheet, depositions. Case record will লিখে ভিতৰত পেকেটত এনেকে দি ল'ব পাৰি। চেক কৰি। এইটো 22। 22।
Lord, 23, my lord, kindly take up this matter at 2, my lord, as the conducting advocate is not available. This time. In this case, my lord, charge sheet submitted.
What happened?
Lordship, this is a case, Lordship.
In DPS case, my lord, 22C.
See, Lordship, basically, Lordship, we have filed this case based on the ground that, Lordship, section 47 and 48 not complied with. And on that ground, Lordship, charge sheet may not be barred, Lordship, for granting bail to the petitioners, Lordship. We have annexed
page,
Lordship, 21 may be same. Arrest memo, page 21.
This is the arrest memo, no? You have the notice.
And notice also, Lordship, page 22. Annexure 5. In both 47 and 48 not complied.
You can take instructions.
Yes, my lord. Scan copy may also, my lord.
Yeah, also instructions regarding that part.
Yes, yes.
He's on a limited mandate now.
Yes,
So
yes.
just stick prima facie. I mean, of course, this must be the one since you have annexed, but this will not meet the standard. So
Yes,
you just check it once,
yes.
cross check it once. The scanned, we have called for diary. It is at the stage of investigation, I think.
No, my lord, search sheet submitted today.
Submitted by the learned counsel, Mr. Sarkar, it is Sarkar, that the petitioner is assailing his arrest due to non-compliance with the notice requirements under 47-48 BNSS. It is also submitted by the learned additional PP that in the meantime, the case has been charged sheet. Do you get the scan, you know?
Scan search sheet, my
You,
lord.
call for the
Along with
scan
the
copy of case diary and charge sheet. And the learned prosecution shall also take the instructions regarding the compliance with section 47-48. Is it?
Yes,
That also you can do, you can WhatsApp you, right?
yes, ma'am.
List the matter on.
On my lord, 411.
411.
411.
I know.
My pleasure, Lordship. So earlier TCR was called for, Your Lordship, and
No, scan copy not yet received, ma'am.
Oh, please not, let us sit down, please, please not.
I have taken a step on 1610, Your Lordship, but
You have taken
Lordship,
steps, no?
Lordship,
Steps. you have
I may
taken.
be allowed to take fresh steps.
Oh, yeah, because that was last here says steps not received. Okay. Issue reminder for the scanned TCR within bracket containing case diary, charge sheet, depositions, if any. Full stop. Here is the office note dated 16/10/25. The petitioner counsel undertakes to take fresh steps upon the R2 informant. List on 10/11.
Yes, 1011.
10/11.
Lordship.
May I please, Your Lordship? Your Lordship, kindly pass over the matter for the time being.
Sometime.
Much obliged.
My lord, 27, my lord, I have checked LCR, TCR received, my lord, voluminous TCR, my lord. Here, my lord, it will take some time because grounds here taken is that, my lord, those section 48 notice was not, my lord, communicated, but not in vernacular. That is the ground, my lord. Huge
But
amount of,
not in vernacular.
yes, my lord, huge amount of contraband, my lord, 60,000 Yaba tablets and heroin is.
60,000.
60,000 and heroin is also there, my lord. I need, because voluminous TCR, my lord, I need some.
On the last date also, the prosecution has
So you
taken
are
time.
challenging, sir, on this basis of this
Challenge-
notice.
No, on two aspects, Lordship.
Notice of the-
Notice under section 47 and 48 as well as on medical ground, Lordship. He is 70 years, the accused is 70 years, he is behind the bar for 6 months.
That will be slightly secondary since it's a commercial quantity at the moment.
Yes,
But we have to
Lordship.
see the notice.
Yes,
Notice is
notice,
been
not,
given,
Lordship.
but, it is in, you said it is.
Lordship, it is in English and he is illiterate, Lordship. He is in the notice 47, page 26, Lordship. He has put thumb impression, Lordship.
This, Watago.
Yes.
It is, there's an endorsement that ground of arrest is translated and read over to the accused person as per the local language understood.
Yes,
by-
then.
This you have to cross check.
Yes, my lord.
With the
Then,
record.
then complied with, my lord.
So whether that will suffice,
Yes.
depends, you know. It will usually, otherwise we'll have to go into 37 now,
Yes,
otherwise.
yes.
Okay.
Otherwise, my lord,
Not
if
ready.
those
Lord.
grounds were, my lord, explained and, my lord, then.
We'll take a chance in second half.
Lo-
In the second half, we'll take a chance.
Yes.
Second half. Yes, Lord.
Today, it will be completed. Seven. So,
May it please, Your Lordship.
Yes.
Lordship, in this case, my lord, there is allegation of cryptocurrency, my lord.
Cryptocurrency.
Yes, my lord, but the FIR, 4 names has been mentioned. One Ashadul Islam, Hasanur Islam,
In this
Kobat
case,
Ali,
Rashid submitted, my lord.
Hekmat Ali, my lord. So, my lord, petitioner is, so 60 days offense, my lord. Petitioner today is 47 days. My lord, I am also having one of the order, the main accused, my lord, whose name in FIR, petition, that is accused number 1, has been already been granted bail by this honorable court, my lord, after 50 days. My lord, here I am today for 47 days, my lord. Even
The allegations are this app, no? This cyber,
Yes, my lord,
Cyber.
serious cyber offense, my lord.
because this is the problem. More than
But
10
my lord,
crores, 20 crores.
I am a daily labor, my
After my
lord.
lord filing of charge sheet, right now, he cannot claim bail as a matter of right, my lord. After filing charge sheet, my lord, at this stage,
Cannot
considering
really-
the seriousness of the matter, my lord.
No, my lord, 60 days offense, my lord. The main accused has already been
60
given
days
bail.
for filing charge sheet, my lord, but within that mandatory period, charge
Charge
sheet
sheet has been filed. yes.
already submitted.
No, sir, FIR was lost on
Not my lord, here 90 days, 111 my lord, organized crime is also.
No,
there.
my lord, in my case, my lord, there is
111
no
of DNS
previous,
is also there, my lord.
I have no previous record.
Yes, that has become secondary because
Yes,
charge sheet has been
yes,
filed.
second.
Even if it is
charge
60
sheet
days,
submitted.
charge sheet-
Whether in charge sheet my name.
Anyway, 60 days or 90 days, it is not, my lord, now immaterial, my lord, after filing of charge sheet.
No, my lord, charge sheet may not be a bar, my lord.
No, it's not a bar, that is
But
settled.
my lord, against whose charge sheet is submitted? My friend, my lord. may
No,
contact.
that is not clear, whether he has been charged.
Yes, my lord. Whether he has been suspected or not. That is relevant, my lord.
Can I see
Then
the
I will get,
FIR?
then I will get specific instruction regarding the present accused, my lord.
Okay. That you can do, it is submitted, Mr. Khandakar, Learned Counsel submits that perhaps the case has been charged sheeted in the meantime. And one co-accused, Asadul Islam, was granted bail on 21/8/25 by coordinate bench of this court in BA 2393 of 2025. Good stuff. Three accused persons were named in the FIR along with unknown others. Good stuff. The learned additional PP undertakes to take instructions regarding the accused persons against whom the charge sheet has been submitted and the penal provisions therein, right?
Yes, ma'am.
You take the instructions.
My lord, day after tomorrow, my lord.
I'll leave it to him.
Yes, on 31/10,
31/10.
I'm leaving.
Today is fixed for case diary, my lord.
Will opens.
Lordship, kindly peruse the FIR, lordships. 8, page 8.
NDPS case?
yes, 29 case I received, my lord.
In this case, my lord, one contumace,
Sure. Country made pistol.
recovered, pistol, recovered from the backside of the house,
Hmm.
not in the premises of the house, my lord. The pistol is not belong to them, my lord, actually. Or 60 days, I guess. 7 years. 53 days will go, 7 days.
Anyway, madam,
And 53 days are gone, my lord.
he's in custody since?
Since, my lord, 3/9/2025.
Diary has come.
Diary received, my lord.
Investigation?
Investigation, my
completed.
lord, yes, otherwise the statement of the accused person is there and that country made, my lord, pistol was recovered from the residence of the present petitioner, my lord. And.
Not residence, my lord, it is
uh,
this in the
Side of the premises.
yeah,
the
backside of the house,
Yes,
my lord,
bond,
and in
with
the
the
rejection order also, it is shown that it is a backside of the house.
Within
that
her
is placed-
compound, my lord, within her compound. And my lord, from her statement,
mentioned.
from her statement and my lord statement, she stated that
See?
that they are involved in, my lord, in drugs business, and for doing all this
Okay.
business, they keep.
Kept
all-
a pistol.
Yes, keep.
No drugs, here. This is all, not
No
entered.
drugs,
No
not
drugs.
recovered.
Anyway, anyway.
7 days to
Can I have
60 days.
Yes.
Hey, Devi, learned counsel for the petitioners and additional people. People that- No, it will- it will available. Pranav Bhagwan. Pranav, that way to keep quiet available for better. Go, one time. Very well. 483 BNSS application. Gulabganj PSPS number 217 of 25. Under 25(1) Capital A Arms Act. The accused was arrested on, the accused persons, the two accused persons were arrested on 3/9/2025. The gist of the allegations in the FIR dated 3/9/2025 is about recovery of a country-made pistol from the premises, house compound of the accused persons. The learned petitioner counsel submits that this, the petitioners do not have any conscious possession of the alleged pistol recovered. Case diary has been received. The statement of the accused persons, both the accused persons, right?
Hey,
Both the accused persons recorded.
Yes, ma'am.
Both the accused persons
Both
have
the
been
accused persons recorded.
Recorded. Considering the length of detention and the progress of investigation, allowed to go on bail up is 30,000. One severity of the like amount, satisfaction of the concerned court. Concerned court is, it will be CJM Dhubri,
Yes.
CJM Dhubri, subject to
CJM
the
Dhubri
conditions
nahi.
that cooperate with remaining investigation. Shall be available for trial if one commences. Number 3, not hamper or tamper with it.
Some product person.
Try to influence witnesses.
CJM, no?
Shall not try to commit any illegal activities. Violation of the return back case diary, bail petition stands allowed and disposed.
CJM ni session court.
The session judge, maybe also.
Yes, session judge, my lord.
That's why I always prefer writing that, keeps it
Yes.
safe. Session judge most.
Session judge.
That ঠিক করে
Really obliged.
কি নম্বর?
Mhm. 30 CD. May I please? 30 my lord, case diary not received.
Case diary have not received. Your lordship, today is 80 days. Can it be fixed on Friday?
Friday.
Yes.
Friday কি তারিখ হবে?
This is for case diary is not yet received. Like that. It is, the accused was arrested on 9/8/25. It's under which, 103.
103.
Actually, Friday,
On
you
4,
can fix,
3 or 4 man.
can it be third, Monday?
3.
Monday.
3/11. Issue reminder for the case diary. No, really, no. After. Yeah. 51, 52.
May I please tell us? Well, in this case, my lord, the instant investigation was done pursuant to the court's order. However, my lord, for the same cause of action, earlier FIR was filed, which was investigated and the charge sheet was laid. Now subsequently, another FIR was lost.
For the same cause of action.
For the same cause of action, which was investigated and police filed final report saying that the case was earlier investigated for the same cause of action. It is the contention of the police matter. However, on the basis of protest petition matter, another investigation was ordered by the London magistrate. And on the basis of that investigation, police filed charge sheet again. This is my case, madam. And it is reflected in the, my lord, the statement under 161 and 164 of the victim matter.
So this was, after this protest petition,
Yes, my lord.
was again investigated.
Again investigation.
And this time charge sheet was submitted.
Charge sheet was submitted. And
But
earlier
then
also charge sheet was
There
submitted.
cannot be two trials.
Two trials, my lord.
You are appealing for amicus.
My lord, yes, I have gone through the, my lord, scan copy of the case record, my lord. Here within initially, my lord, one kidnapping missing report was lodged on 29/10/23. Thereafter, in this case, my lord, within a period of 3 days, my lord, on 31/10/13, my lord, charge sheet submitted. 23, my lord, in a period of 3 days. My
3
lord.
days, charge
3 days, within a period of 3 days. Thereafter, my lord, in this case, my lord, again, the victim, my lord, implicated the accused petitioner, my lord, and thereafter, my lord, this case, the present case, my lord, trial, at present, my lord, trial is.
So that
going.
means, are you saying that there are two trials going on now?
No, my lord, initially, my lord, in that case, my lord, already, under, that is in the first case, my lord, in that case, charge sheet already submitted. The second case, my lord, actually, my lord, police has not submitted, final report submitted, my lord.
But Nara's
That
petition-
in that this case is, my lord, already earlier investigated. So, my lord, there is nothing to investigate more, my lord, in that case, my lord.
That's a wrong approach.
So
Why-
earlier
it has to be-
already.
why it has to be amalgamate.
Yes. So thereafter, my lord, in view of that, my lord, now on the basis of the protest petition, my lord, trial of the present case is going on, my lord.
As a complaint
A
case.
complaint case, my lord, registered as FIR, my
The
lord.
complaint case which is forwarded to the
And
PS.
victim, my lord, implicated at this point of time, victim implicated.
Victim has been
there.
examined.
Yes, victim, my lord, implicated.
Scan record is there.
Well, I'll.
Madam, kindly see forum one page 22. 22 is the final report.
Victim examination.
Exams. Page 22, the final report which is submitted by the police in this instant case. Kindly see page 24, my lord. Same incident, same cause of action, which is also narrated by the victim in her statement, my lord. Both before police and both before magistrate.
Scan record is received with regard to the present complaint case.
My lord, both is there, my lord. I will point out, my lord. Your lordship may kindly.
Agwai report. Mr. Das, you are appearing for as amicus. Also guide the court. Record to be.
52, my lord, I am trying to get the instruction regarding, my lord, service of notice, my lord.
It's a POXO matter.
Yes, POSCO matter, my lord. But till now, my lord,
2025. 10-2, quite long back. Issue reminder for the case diary. The interim bail granted by order dated 10-2 stands extended in the next date of listing. Fix on 11/11.
yes, my lord.
11/11.
Me, please, your lordship. Lordship, it's an anticipatory bail application filed under 482 BNS.
Petitioner is in interim, my lord. Here updated case diary not received.
Not received. So. Fix another date or you want to say
Yes,
something?
madam.
Your Honor, interim dated 28/4/2025. Since then, the up-to-date CD has
Not-
not been received.
It has not come. Long time, huh?
Long time, your lordship. And moreover, actually, the allegation made in the FIR was the FIR is in page 16, your lordship, vernacular. May I read?
Yeah, go ahead.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজীৰ ৭-১১-২০২৪ তাৰিখে উপৰোক্ত পদকীয়া দুয়োত মোৰ ঘৰত আহি স্বৰ্গীয় মানিক চন্দ্ৰ চৌধুৰী পিতা গন্ধৰাম চৌধুৰীৰ নামত উত্তৰাধিকাৰীৰ প্ৰমাণপত্ৰ বিচাৰি আহে। উক্ত সময়ত মই বহুত ব্যস্ততাৰ মাজত থকাত তেওঁলোকে নিজে প্ৰমাণপত্ৰ লিখিব বিচৰাত মই লিখিব দিওঁ। প্ৰমাণপত্ৰ নং 488 খন মই নিজে পঢ়ি বুজি চাই চিল চহী কৰি দিওঁ যদিও পদকীয়া দুয়ো পিছত উত্তৰাধিকাৰীৰ নামবোৰৰ বিপৰীতে ওৰফ শব্দ ব্যৱহাৰ কৰি আন 3জন ব্যক্তিৰ নাম লিখি দিয়ে। পদকীয়া দুয়োৰ বিৰুদ্ধে গাঁওবুঢ়া প্ৰমাণপত্ৰ জালিয়াতি কৰাৰ অভিযোগ আছে। Your Honor, actually, Lordship, actually this allegation was of 2/11/2024 and the present FIR was lodged on 23/2025.
Okay. After
After a
lapse of several months.
Yes, Your Lordship. Actually, the story is that both the accused person are cousin brothers, and the deceased, whose next of kin certificate was issued by the informant, he was the grandfather of the present accused persons. So what happened after the granting of this particular next of kin certificates under government scheme, the land of the present accused persons were taken off by the government, and under that scheme they were paid a lump sum amount, both the accused person. And what happened, the Gaubura, that is the informant, kept on budging the accused person to give some portion of the money to him. The Gaubura, that is the informant, along with his son. But when the present accused person denied the request of the informant, he simultaneously threatened them that he will take legal action against them under certain circumstances, and hence this FIR.
Right.
So the colorable of the FIR can be taken up by the difference gap between the incident and the FIR.
FIR. Third, J. Das, Learned Counsel for the petitioners. Additional PP, Gorthakot. Case diary is not yet received. It appears that the case diary, the present bail petition is pending for case diary since 28/4/2025, on which day the petitioners were also granted interim bail. Full stop. The Learned Counsel for the petitioner points out the elapse of considerable time between the alleged incident and the filing of the FIR, constituting several months. Full stop. The IO cell positively sent the case diary
Yes.
by the next date. Interim bail granted by order dated 28/4 stands extended till the next date of listing. Get it, so
Yes.
so that
Yes, on
petitions
7.
will not keep hanging.
Yes, on 7/11, I will try to.
7/11.
7/11.
Make it on 6/11.
6/11.
6.
6/11. Obliged.
Mail, Teja Lord.
This matter may kindly taken up, my lord, after some time Excise Council of the Excise Department will appear, my lord. He. Please, your lordship.
It was sent for updation.
But this, your lordship will kindly take up
Wildlife,
order dated 24/7/2025, ma'am.
24/7.
2025, ma'am. My lord, I'll just give a brief of the case, my lord. In this case, my lord, 28 pieces of, my lord, red sandalwood were found in the possession of one person, my lord, Matla Murmu. Matla Murmu was subsequently arrested. On the statement of Matla Murmu apparently implicated me, that it was intended for me, my lord. Thereafter, my lord, that is why on apprehension, we filed this anticipatory bail application.
Okay.
Yes. So, my lord, here,
Interim
before
has
coming on
been
the legal,
granted.
legal
Interim
issues.
is there. Interim is there.
Interim is not there, my lord.
Not there.
Not there, my lord.
Yeah.
Here, my lord, basic issue is which your lordship will examine is whether mere possession of sandalwood, red sandalwood, is an offense under which this FIR is registered. Because at the end of the day, your lordship will decide whether my custodial detention is required or not based on the offenses which have been attributed to me in this case, my lord. Now, your lordship will kindly see that this FIR has been registered under sections 303 subsection 2, that is theft. Next is, my lord, 317 subsection 2, that is receipt of stolen property. Then another is, my lord, 3175, that is, my lord, when there is that is again, my lord, regarding this stolen property. So 303, 317, these are regarding, my lord, when the subject matter is stolen property. So the first requirement would be that this red sandalwood which has been found has been stolen. So somebody has to come forward and say that my red sandalwoods have been stolen. That can either be the government or it can be a private individual. So first thing is that. Next, my lord, this case has been registered under sections 24, 25, 40 and 49 of the Assam Forest Regulation. Now, sections 24 is, my lord, penalty for trespass or damage in reserve forest. Here, there is no such allegation. 25 is basically, my lord, setting fire or felling trees or quarrying stone or breaking up of any land, my lord, in reserve forest, my lord. Section 40 is basically the power of the government to frame rules regarding transit of forest produce. It is not even a penal offense, my lord. And section 49. 49 is seizure of property liable for confiscation. So these provisions, 40 and 49 are not penal provisions, 24 and 25 are on the face of it not attracted in this case. Now the most important sections which have been invoked here are sections 17C, 17D and 51 of the Wildlife Protection Act. For that, I'll request your lordship to
offenses.
Wildlife. I'll request your lordship to kindly take up the Wildlife Act first.
Diary was not received, right? Diary.
My lord, in the last occasion, it was reflected that there is no appearance by wildlife department. But my lord, this is a PS case. So the CD will have to be produced. Yes.
Here what had happened, my lord, initially state was appearing, but considering it's a wildlife case, my lord, so this honorable court had directed somebody from the wildlife department to also assist this honorable court on these issues.
And so is appearing.
Yes, my lord. So now 17C, my lord. 17C of the Wildlife Act, your lordship will find it at page 15 of the Act, my lord.
Hmm.
17C. 17C is cultivation of specified plants without license prohibited. So it is prohibiting cultivation of certain special plants. 17D is dealing in those special plants. Now your lordship will kindly see these are chapter 3A offenses. Now your lordship will kindly come to the schedule, my lord, the third schedule that your lordship will find in page number 144.
Schedule 3.
Schedule 3. Now schedule 3, my lord, this list does not contain red sandalwood. The red sandalwood, the legal name is, my lord, the Pterocarpus santalinus. So that is not there in schedule 3, my lord. So if it's not there in schedule 3, so 17C and 17D cannot be invoked if it is not there in the schedule. Now your lordship will find red sandalwood in schedule 5, page number 205.
Schedule 5.
Yes. Against entry number 444, my lord.
This Tantalinus.
Yes, my lord. So it is only in schedule 5 that this appears, my lord. Now,
schedule 5 is about what?
About your lordship. For that, your lordship will kindly come to. Sorry, my lord, schedule 4. I'm sorry, my lord, schedule 4. Your lordship will kindly come to page 145. Schedule 4 starts here, my lord. And it's basically deals with offenses under chapter 5B.
Just a minute. 145.
145, my lord. Schedule 4 starts, my lord.
Schedule 4.
Yes, chapter 5B, my lord. And now your lordship will kindly come to chapter 5B.
Chapter 5B.
Chapter 5B starts at page 47. So it is regulation of international trade in endangered species of wild fauna and flora as per Convention on the International Trade in Endangered Species of Wild Fauna and Flora. So the list which is there in Schedule 4, my lord, it is the prohibition is there regarding international, unregulated international trade. So if all of this is conjointly seen, what emerges in my respectful submission before your lordship is that it is only the unregulated international trade of red sandalwood which is prohibited.
Okay.
So that no chapter 5B offenses has been invoked in this case. There is also no allegation that this red sandalwood which was found in the possession of the co-accused has anything to do with unregulated international trade. So your lordship has seen that the BNS offenses are all not attracted in this case because there is no allegation of theft. Forest regulation offenses are also not attracted in this case, my lord, because there is no allegation of felling trees or trespassing into reserve forest. Wildlife offenses, my lord, the offenses which they have invoked are not attracted because that is not covered in the schedule. Schedule covers only unregulated international trade. So all of the sections which have been invoked in this case or which could have been invoked in this case, my lord, are not attracted in this case. So legally also, my lord, there is no penal offense which can be attributed to me. And factually also, this is a case where the entire case against me is based on the statement of the co-accused, who says that this red sandalwood
Was kept for you,
was
kept by
for-
you.
kept by me, my lord. So that is my respectful submission before this honorable court. Otherwise, I am more than willing to appear and cooperate with the investigation. And this bail application has also been pending for a long time, my lord. Yes, my lord. Since July. my lord.
Where is the FIR or whatever?
FIR lordship
offense
will
report?
find at page 14.
Sorry. Petitioner is Binoy
Binoy
Bhagat.
Bhagat, my lord.
Binoy
So I had allegedly kept the sandalwood in Matla Murmu's house.
And heard S. Nawaz, learned counsel for the petition, an additional PP for the state of Assam. E. Bhagat. And yeah,
I bought it.
yes, you are I Bhagat, appearing for the forest department. The এইটো আমাৰ এইটো আপোনাৰ 24/7/25 first second paragraph to ল'ব পাৰে second and third paragraph. They say the case diary as called for has not yet been received.
Is there received, madam?
Oh, it has been received.
Received, madam.
I see.
Is it received?
So I was not,
Yes.
I thought I have to decide about
Yes, madam.
interim.
My lord, in this case, my lord, yes, regarding on the basis of the statement of one Motila Murmu from the residence of Motila Murmu, those 28 numbers of my lord sandalwood were recovered.
Malta Murmu.
Yes. And thereafter, my lord, his statement is that it is the present petitioner who kept all these sandalwood in his house, and those my lord sandalwoods were kept in a concealed manner. So it why my lord he kept those sandalwood in a concealed manner, my lord, that is till now regarding that. My lord, investigation is only his custodial
What,
intervention.
28 pieces?
Yes, 28 pieces. And regarding whether those red sandals were in any manner were related to with my lord any my lord international trade or not, my lord, regarding that aspect till now, my lord,
Nothing.
regarding that
It's under investigation.
it would require further investigation, my lord. And till now, regarding identity of those sandalwood, already my lord letters were written by the my lord submission of by the IO to the my lord to the forest to the concerned authority, but till now, my lord, that report not yet received, my lord, regarding
I'll have a look. Huh?
Yes.
It is submitted by the learned counsel for the petitioner, so Nawaz, that the ingredients of the provisions of BNS would not be attracted in the instant case. And it is further submitted that sections 40 and 49 of the Assam Forest Regulation 1891 do not constitute penal offences, and the other two sections given of the said regulation, that is section 24 and 25, are also not attractive because of the nature of the allegations. With regard to the the penal provisions of the Wildlife Act given, the learned counsel has taken the court through the relevant provisions of the Wildlife Act and the connected schedules, and submitted that the penal provision that the criminal liability could arise in an instant case only if there is materials to indicate unregulated or illegal international trade in the sandalwood. The learned additional PP submits that investigation has also confirmed that the 28 pieces of the red sandalwood was recovered from the house of the said Malta Murmu, and that it has emerged from the said person that the present petitioner had kept the said sandalwood in his house. Full stop. As far as the aspect of international trade is concerned, so far the materials do not indicate that, but the said aspect is under investigation. Full stop. What did you submit is okay, factually correct.
Yes.
Mr. Bhattagur, what did you like to submit? You also heard learned. If you want to say something, I can record. Otherwise, it's okay.
Only thing is, we have not been given any copy, my lord. to
No,
go through.
copies were furnished twice, my lord, because but Mr. D Gogoi, furnished to Mr. D Gogoi, perhaps he's not there today.
Anyway, heard. Heard. Stop. On considering the facts and circumstances, and also seeing the progress of investigation so far, and the submissions of the counsels on both the sides, I am of the considered view that giving opportunity to the petitioner to render his cooperation to the investigation and recording his statement might rather facilitate the investigation. Stop. In such view of the matter, the bail petition is allowed, and it is directed that in the event of its arrest, so in connection with this case, 25,170 to the satisfaction of the arresting authority, and subject to the condition that he shall cooperate with the remaining investigation and shall make himself available for examination for the IO, shall not hamper or tamper with evidence, shall not misuse his liberty to commit any illegal activities, including any activities prohibited under the Forest Act, wildlife, any activities prohibited under forest and wildlife laws. Standard They'll send return back the case diary. Bail petition stands allowed and disposed of.
I'm deeply obliged.
Yes, 36 minutes, search sheet submitted in this case.
What's the matter? It is theft.
Yes. Regarding submission of forced educational qualifications certificate at the time of filing nomination paper.
Or nomination.
During panchayat election.
That's in principle, it's Not a light offense.
Yes, my lord.
Public representative,
Yes, my lord.
what to do then?
If I should come in, then can.
Well, he's already on interim.
Let him appear before the trial court, my lord. Trial.
He's already on interim.
Oh, already on him.
28/7, no? Say, first, second, additional PP number to lay over. The allegation in the FIR dated so and so, dated 27/6/25, is that the accused, Halima Khatun, submitted post educational qualification certificate while filing a nomination for a candidate for Panchayat election. She was granted interim bail by the order dated 24/7. Learned additional PP submits that in the meantime, investigation is completed, resulting in a charge. In the safe situation, the interim bail granted by order dated is hereby made absolute, subject to the condition that she shall be available for the trial upon commences, shall not hamper or tamper with evidence, shall not try to influence witnesses. Bail petition stands allowed and disposed of. Done.
May I please, your lordship? Lordship, FIR page 11, lordship. The allegation is 137-2.
The new matter
Yes.
we have taken up earlier, this one? No.
No, first.
37 to
My concern.
Oh,
Yes, sir.
So.
Mention now, my lord. In item 28, my
No
lord.
problem.
My
Yeah.
lord, in
what do you-
28, my lord, my lord fixed on Friday, my lord. I have.
This Friday?
This Friday. I have instruction to withdraw the case.
We don't know matter.
My lord. 28. Because already search is submitted.
Okay, you want to approach?
I approach.
Botaku, you were dealing with the matter.
28.
No? 28. এইটো কোনে বা লিখিছিল নাজানো দেই। শিবু পাইছে।
That should be.
Mr. Khandakar, M.R. Khandakar, learned counsel appearing for the petitioner, submits that in the context of withdraw, charge sheet having been filed in the case, he seeks to withdraw the withdraw the proceeding before this court. The prayer is allowed. The case is disposed of on withdrawal. Huh?
Yes,
Shibu?
I am the.
No problem.
May please, your lordship. This case is entirely false case. And what already call for the case day.
Case they will
There are false cases, definitely.
Yeah,
should be able to see through them.
no, your lordship. The Salim, one of the company, when check is presented to the bank, Salim is the employee of the complainant. He was present. But when check amount is drawn, complainant is given the consent to draw the amount.
I'll just have a look at the FIR.
Yeah.
CD is not received.
CD received, man. CD received. He is in interim, my lord. Appeared
Interim bail, he is in.
statement recorded, man.
I'll just read, huh? Just give me 2 minutes. It's with my own customer and also issue the check of paper of cash of. Okay.
Now, your lordship, I have already submitted 3 decisions also in this case, regarding Supreme Court's latest decision. And your lordship, when check is done, I have already submitted, the complainant given the consent to the branch manager. There is a sufficient evidence. How it can be stolen, but it is an entirely false case. It is the due amount. There, he is just is a
8 lakhs.
is a due amount. His father, from his father taking the so big amount. I am so
By putting the amount and without any file.
No, in subsequent, 25/7 to the, taking the, 4,50,000, 13/11, 24, taking the 1 lakhs, and 18/3, 18/3, 3 lakhs, and David Kolita, 8/5, 50 lakhs. It is a due amount what the check is given the total amount 8 lakh. So, there is in strong evidence that Selim is a company. One check is bring to the bank and submitted at the bank.
What is the investigation?
Yes, case diary received, my lord. Otherwise, he is in interim appeared statement recorded, but I have received the, my lord, bank statement of the present petitioner and the check, my lord, photocopy of that check.
Allegation is that he filled in the details and encashed it in his name.
Yes, in his own, by, my lord, one check was issued by one Narayan Das, my lord, in respect of, my lord, my lord, regarding purchase of some tires. for
Tire.
the, my lord, shop of the company, and thereafter, at that point of time, name of the, my lord, there is only the amount was there, my lord. No name was mentioned in the check. Later on, my lord, David Kolita taking that advantage by
Who was an
putting-
employee?
employee by putting his name, deposited the check in his account. Regarding that aspect, my lord, bank account of the present petitioner, my lord, revealed yes, that my lord Bhetapara SBI Bank, my lord, my lord deposited that check, and in his account that amount was deposited, my lord, 8,04,500.
Your lordship, he is not employed. He is not at all employed. One employee is accompanied just a six. It is entirely false.
Then if he has illegally taken the money, it has to be returned.
Yes.
No, the forensic will prove. It is not, he, complainant is written, that's it.
His bank statement, my lord, second page regarding that. And regarding, my lord, whether he has, he appeared, his statement is also there in the case.
What is saying? Could you go through his statement?
Yes. Regarding his statement, my lord, I have not checked. I have checked the, my lord,
How is he defending himself? Can I have a look?
yes. I will point out.
No, he is a plumber. He is a private worker. He is not employed.
Anyway. And P. Bothago additional PP for the state.
What?
The case arose out of the FIR dated 2/7/2025. 7/1. No, 2/7/25. Logged by one Dalit Singh Sodhi. The allegation that a check of 8,04,500 given by one of his customers. By filling in only the check amount and leaving the other particulars blank. Stolen by his employee David Kolita, the present petitioner, who later encashed the check and took the money in his own account.
No, my lord.
That's the allegation.
No, allegation.
Stop. Case diary has been received. The petitioner was granted interim bail on 1/9/2025. Learned additional PP submits that pursuant to grant of interim, he appeared before the IO and his statement has been recorded. Is submitted by the prosecution that copies of bank statements procured during the investigation indicate receipt of similar amounts, the account of the petitioner. Got it?
Yes, ma'am. মই মেলত আই এম জাষ্ট পইণ্টিং মই যিকোনো দোকানত কাম পালে হাজিৰা হিচাপে কাম কৰোঁ যোৱা 17/6/2025 তাৰিখে মই দলজিৎ সিং চৌধুৰী লখৰাত থকা টায়াৰ দোকানৰ পৰা এখন চেক চয়েঞ্চো চেকখন নাৰায়ণ দাস নামৰ ব্যক্তি এজনে টায়াৰ দোকানী দলজিৎ সিং চৌধুৰীৰ নাম নিলিখাকৈ চেকখন দি থৈ গৈছিল আৰু চেকখনত মাত্ৰ এমাউণ্ট লিখা আছিল 8,04,500 টকা আৰু মোৰ দেউতা দিলীপ কলিতাই দলজিৎ সিং চৌধুৰীৰ পৰা উক্ত টকাটো পাব লগা থকা বুলি কোৱাৰ বাবে দেউতাৰ নিৰ্দেশ মৰ্মে এই চেকখন নি ষ্টেট বেংক অফ ইণ্ডিয়া ভেটাবাৰ ব্ৰাঞ্চত নি টকাটো মোৰ একাউণ্টত ট্ৰেন্সফাৰ কৰিলোঁ that is his statement.
Peruse the statement of the accused recorded by the IO pursuant to his being granted interim bail. Considering the progress of investigation and the cooperation rendered by the petitioner, despite the adverse materials, I am not inclined to cancel the interim bail granted. Accordingly, the interim bail is hereby made absolute, subject to the condition that he shall render cooperation to remaining investigation, and shall not hamper or tamper with evidence, and shall be available for facing the trial if one commences. Return back the case that the conduct is not good.
Yes.
Anyway.
Must good.
I'm on interim, man, and I have already appeared, man. FIR at page number 11.
I'm sick.
My lord. A person, my lord, namely Tuman Sonwal, he, along with a pistol, my lord, he has surrendered before the
Police.
OC, my lord. OC of the.
And thereafter he was arrested.
He was arrested, my lord. He has said that arm was, he has received from one unknown person, my lord. And that unknown person was also arrested, my lord. That is page number 14. But both of them were known to each other. And that unknown person said that he has received it from me, my lord. That is Pranav Rao. That is the case, my lord.
Investigation.
Yes, Investor Tumon Sunwal's statement is also available, and my lord, one Tumon Sunwal handed over the pistol to the police station, my lord.
That is good.
Yes, thereafter, my lord, he stated that one name of one Ganesh Boro. Then statement of Ganesh Boro is also available. Ganesh Boro stated that this is, my lord, the present petitioner who handed over the pistol for keeping it for some time, my lord. And thereafter, as per his instruction, he has handed over to that Ganesh Boro handed over this to that to Tumon Sonwal.
Also, he petitioner is not Tuman Sonwal.
Petitioner is not the petitioner is the person, my lord, who actually handed over the, my lord, pistol initially to Ganesh Boro.
Who in
And,
turn handed over to.
as per the instruction of the present petitioner also, Ganesh Boro handed over this.
And it was, my lord, supposed to be delivered to me as per allegation. But this Tonul Sonwal, my lord, he has kept that arm for more than 6 months, my lord. It is reflecting the affair itself, my lord. He has never tried to deliver it to me.
His statement has been recorded?
His statement, my lord,
Probably.
yes.
Charlie.
Yes, his statement recorded, my lord.
First three paragraphs say. Stop. The petitioner was granted interim bail on 22/9/25 with conditions pursuant to which he stated to have appeared before the IO. and his statement record. Case diary has been received. Learned additional PP submits that the case was registered upon 1-2 months Sonwal, handing over the pistol to the police station. And investigation is revealed that the present petitioner had given the said weapon to one Ganesh Bor, and along with instructions to hand it over to 2 months Sonwal. Nevertheless, I'm not inclined to cancel the interim bail granted to the petitioner. Accordingly, the interim bail is hereby made absolute, subject to the conditions that shall cooperate with the investigation, not hamper or tamper with evidence. Return back the case diary. Stands discussed. There's some progress in the investigation.
Yes, sir.
Obliged.
May I please? 482 application. CD was called.
41 case diary not received.
NDPS.
Though NDPS, I am no way involved in this case. The main accused from whom this contravention was seized, he has been released from the bail. And police has been frequently visiting my house in search of me, man. Nothing is there.
See the other. Jorhat, from Jorhat.
Jorat. The contravention is from a lady who has been arrested and she was granted bail. Thereafter, police has been frequently visiting my house in search of me.
Then how, this? She has not mentioned your name, right?
Nothing, nothing, no. The contravention was specifically seized from this lady, your lordship.
Yes, Husna Begum.
Jusna.
Case diary will reveal whether how he is involved.
Who is he?
This is a local,
Javed Ahmed.
of that locality.
He's been summoned by the police.
Not, but frequently visiting his house.
He has been visit. Get the case diary?
Yes.
The case diary as called for is not yet received, full stop. Here is the FIR. Stop. Issue reminder for the case diary. List on.
On my lot, 12-11.
Is it okay for you? 12. Husna Begum I have dealt with. When I was there. Obliged.
May it please your lordship. What you may kindly see FIR is 13. 42, my lord, case diary not received. My
Lordship, earlier occasion was also CD not received, Lordship. And we are not on interim. 18 petitioners are there, Lordship.
There are other allegations against her, them, no? POXO, so many. No, 43.
May I please, your lordship?
Yes.
I am an interim lordship. I appear before the IO lordship. Petitioner is an interim lordship, but earlier order lordship, the POXO 6 is there. But notice was not served. In the earlier order also, it was not reflected in the order also.
Vernacular language, in fact, those, my lord, contents of the notices were read over to the accused person and he understand the contents of the same. Regarding that aspect also notice there in there. So this is not a case, my lord, regarding non-furnishing of grounds of arrest.
Both the notices are there.
Even in vernacular language also, my lord.
Bengali also here, it has been
Yes,
written, yes.
yes. That
That
is regarding that also. no, the specific notice.
That's okay. In that case, we'll have to go into 37.
Yes, so
Look,
total
I
six.
have submission, Lord.
Yeah.
May I, Lord?
Yes, please. go
Lordship,
ahead.
just to explain this, the explanation of the IO, I would like to rely on Probi.
Yes, you can guide the.
On the relevant portion of the judgment of Probi Purakaisto, which was also relied in this Bihan Kumar. Para 25, Lordship. Para 25. First para, inside para 20 of the earlier judgment of Lalu Bhai.
Para 25.
Para 25, second paragraph, 20 of Lalu Bhai. May I read, Lordship? Communicate. Communicate is a strong word. It means that sufficient knowledge of the basic facts constituting the grounds should be imparted effectively and fully to the detainee in writing in a language which he understands. The whole purpose of communicating the grounds to the detainee is to enable him to make a purposeful and effective representation. If the grounds are only verbally explained, to the detainee and nothing in writing is left with him in a language, which he understands, then that purpose is not served and the constitutional mandate in Article 22(5) is infringed.
This must have been in the context of, but principles will be the same.
Yes.
This must have been 22(5) since it is referred to. This must have been in the context of preventive detention, right?
Lordship,
This must have been preventive detention.
Lordship,
But
this,
principles are same.
so far as preventive detention and it is being clear that the whole principle is applicable in preventive detention as well as for this.
That's what I'm saying.
Lordship, now I will come to
Specifically preventive detention. Just
Yes.
give me 1 minute. I'll just.
yes, Lordship. I would like
Just a second. 22(5). No, go ahead.
yes, Lordship. The page number 27, 28, Lordship.
Of this judgment,
No, Lordship. The my application, Lordship.
petition, page number 27,
28, Lordship. 11 portion.
translated and.
Yes, Lordship.
Verbally translated.
This contention, this note, in my opinion, this is not compliance of the mandate of the Article 22, Lordship.
In terms of this principle.
Yes, Lordship, above this vernacular, that is Bengali language, there is a note in English. The ground of arrest is translated, Lordship, and read over to the arrested accused person as per the local language understood by him. Where is the translated version, Lordship? Where is the translated version which was read over to my accused? To my understanding,
There is no translated version, only verbally it has been translated.
Yes,
No
Lord.
written translation.
No written translation. If it is being translated, that should be there, which was read over.
Now it is in some of the formats you get.
Yes, Lordship, I would like to submit Lordship, I'd like to submit one format, Lordship.
Earlier, this was the best you could get. I get your point.
Lordship, I would like to place one format in another case of Baksa district.
Handcuff like
This is the grounds of
Yeah,
arrest.
it is like this.
It is in English and categorically,
And to also. Yeah, please.
categorically this was being translated, Lordship.
Nowadays they are bilingual, English and
Yes.
below.
Yes, that is there. Lordship, there also, and in 48 also, 48 there is no any such this endorsement. I am not admitting those endorsement. I am saying that even if there is endorsement, that is not compliance of the Article 22 and mandate of the Supreme Court. In 48 page 30, Lordship.
Yes.
In page 28, there is some endorsement in Bengali language.
It's not
And
here.
in page 30, there is no endorsement, Lordship. So my humble submission is that the police, the court cannot allow to dilute the mandate of the Supreme Court by the police. To dilute the provision of the Constitution, which is my legal right. I am 70 years of age. I am having a lot of medical problems which is available here all medical documents. The jail authority has sent me to medical this SMCH and where I was admitted. And I am not speaking by my merit of the case. I was being brought from my house, and somebody has abandoned the vehicle, and they showed me that I was found in the back seat, and not stated that it was recovered from me. Actually, they are in search of my son, later on who was apprehended, and having not found my son in my house, I was being taken up. And thereafter, subsequently, some other accuser also being taken up. That is the merit, my case, Lordship. So far, my humble submission is that in my case, 47 and 48 are not complied with, and the endorsement will not be the sufficient compliance of the 47 and 48, and sufficient compliance of the Pobi Pro Castro as well as the Bihan Kumar, Lordship. And so far as my medical portion is concerned, for perusal of the Honorable Court, I would like to place page number 31, Lordship. Uh, 32, Lordship. 32, Lordship. It was being sent by the Central Jail. It is a medical report from line number 5, Lordship. He attended SMCH on 21/7/25 and got admitted on the same day under Department of Medicine. He was discharged from SMCH on 1/8, and that is after 10 days almost. As diagnosed case of uncompleted urinary tract infection, grade 2 prostatomegaly, and chronic obstructive pulmonary disease. It is a heart disease, Lordship, obstructive pulmonary disease. He was given necessary treatment as per advice of SMCS in jail. He has again attended SMCS on 18/8 for review. His USG report reveals prostatomegaly with right-sided renal cyst. And also he is having, in page number 46, Lordship, he was having cataract, and other many other issues, Lordship. All the medical documents are there. So far as why I am saying that medical documents, Lordship, these old persons, 70 years old person, he was being arrested by violating all the legal norms, which renders his arrest illegal, Lordship. And thereafter, and that apart, Lordship, I am a local person, Lordship. I would stand trial. I will appear before the court regularly. I am local person of the Kasar. So that is my humble submission, and I may be allowed. So far as this violation of 47 and 48 is concerned, the 37th bar will not come into play. Your Lordship has already, this court has already passed several orders in respect of this. That is my humble submission, Lordship.
My lord, otherwise, my lord, from the record, my lord, I already pointed out to your lordship, most of the pages of the, my lord, trial court record is almost blank, my lord, in Xerox copy, my lord. That is one person, my lord. Otherwise, my lord, regarding in somewhere, my lord, I have specifically, my lord, stated before your lordship regarding that, my lord, notice, 48 notice itself, while accused him, and on the day of the production, the order of the Honorable Trial Court is also there. And in that, my lord, before the Honorable Trial Court also, my lord, the accused was asked, my lord, whether all those provisions at that point of time, there is nothing of the honorable trial court regarding compliance of all these provisions. And thereafter, in this notice, my lord accused himself, my lord stated, my lord, that he after he understanding the contents of the same in a language, my lord, which he can আমি গ্রেপ্তারের কারণটি আমার বাদে আমার সুবিধাজনক স্থানীয় ভাষা বা বাংলায় পড়েছি বা আমি স্বীকার করি একটা বুঝতে পারি। So what more is required, my lord? My lord, in a language, my lord, which he can clearly
Which,
understand.
the 47 notice?
40, my lord, that is the notice annexed in
47.
page
I'm
27.
by the IO.
7, my lord.
This Bengali endorsement.
Yes, my lord. Bengal, thereafter, my lord, LTI impression that
They have got it
document.
written from him.
Yes, well, that document was produced before the trial court. Trial court has also on the day of production passed the order. And my lord, regarding my lord, age of the accused, that my lord, he is a 70 years old. My lord, maybe he is a 70 years old person. My lord, it cannot be said that a 70 years aged person may also be a fit person to involve in this type of my lord,
Yes.
offenses.
Can be.
And
Maybe.
by taking advantage of his age also, he may be involved in committing in this type of my lord heinous offenses, my lord. And he may be, his son is also involved, my lord. He is, my lord, on behalf of the son, he may be the main person who may my lord, commit all these offenses, my lord. But that cannot be a ground that only because 70 years, my lord, he cannot be involved in some cases, my lord, 80 years persons also, my lord, fit. And that point of, if a 80 years person is also fit, he can also be involved in committing this type of offenses, my lord.
Only my submission is that two-line endorsement is not the grounds, Lordship. Cannot be
And
treated
my
as the communication of the grounds, Lordship. That means IO or the police will be allowed to dilute the provisions by endorsing that I have explained him. That cannot be. What explanation he has given, that should be there. And that is in English. That I do not understand. Suppose I understand that আমি গ্রেফতারের কারণটি আমার কাছে সুবিধাজনক স্থানীয় ভাষায় so and so. Is it the compliance of the grounds of arrest? Is it the communication of the grounds of arrest, Lordship? That is my submission. My submission is purely on law. That cannot be that endorsement, even if we admitted that endorsement cannot be a grounds of arrest in terms of the mandate of the Supreme Court laws.
Dictate. No, done.
Yes, in page 26 in 47 notice also, my lord. I am just only pointing out the above, my lord. আপনার জ্ঞাতার্থে নিম্নে উল্লেখিত মোকদ্দমা সংক্রান্তে আপনার গ্রেপ্তারের বিষয়ে অবগত করা হলো মোকদ্দমাটি আরক্ষী পুলিশের নিকট জামিন অযোগ্য, কিন্তু আপনি জামিনের জন্য ক্ষেত্রাধিকার আদালতের আইন অনুসারে আবেদন করতে পারেন। So these are most
But
of
নিম্নলিখিত, all these are in English.
They have gone some distance. The
Yes.
question is whether it is sufficient or not. That has to be decided.
নিম্নলিখিত all are in English.
Anyway, have a seat and just take 5-6 minutes to dictate this.
Otherwise, contraband is, my lord, huge quantity, 60,000
Yeah,
tablet and, my
that's-
lord, 396 grams of heroin.
These are anyway heard Sri Jaragulla Learned Council. Your name also?
Yes,
Yes, Learned Councils appearing for the petition. Also heard P. Bhattakur, Learned Additional PP for the state. The petitioner Rajak Mia Barbia invoking the powers under section, the provisions under section 483 BNSS, seeking bail in connection with Silchar PS case number 461 of 25 under section so and so of the NDPS Act. Full stop. After completion of investigation, charge sheet was submitted, giving rise to NDPS case number 77 of 25, which is stated to be pending. It's pending for trial, right?
For trial and one accused is absconding.
It's pending for trial before the court of the learned session judge, Silchar Kasar Chilsar. Full stop. And one of the accused is stated to be absconding. The present petitioner seeking bail was arrested on 29/4/2025. The case arose out of FIR dated 29/4/2025. pursuant to a search operation based on information. And during the search, large quantity of psychotropic substances in the nature of yaba, suspected yaba tablets were recovered. And as the said quantity prima facie fell in the bracket of commercial quantity, the case was registered under the said penal provisions. Full stop. In view of the above nature of the penal provisions, the rigors of Section 37 of the NDPS Act would be applicable and have to be tested. However, the learned counsel for the petitioner submits that he is resting his contentions primarily on procedural infirmity at the time of arrest of the petitioner. It is contended that in the notices under Section 47/48 BNSS have been rendered in English language, which is not a language understood by the petitioner. Full stop. Though there is an endorsement about the same being read over in local language to the understanding of the petitioner, it is contended in this context that the same would not suffice to meet the constitutional mandate under Article 22(1) of the Constitution. In support of the contention, the learned counsel has referred to the leading case of Prabir Pukastal and drawn my attention to paragraph 25 therein, where referring to another decision of the Honorable Supreme Court rendered in the 80s pertaining to preventive detention, the aspect of proper communication has been delved into. Full stop. On the basis of these principles, it is contended by the petitioner counsel that the nature of the notices in the instant case would not would still be violative of the constitutional provisions, thereby entitling the petitioner to bail in terms of the law laid down in Prabir Pukastal, Supra, and Bihan Kumar. The scanned case record has been received. Learned additional PP has taken the court through the contents of the notices under 47/48 BNSS, and submits that the said contents are more than sufficient to comply with the requirements of the petitioner and his family member being sufficiently informed about the grounds of arrest. It is submitted that when an endorsement also has been made about having been explained having been explained the grounds of arrest in a language understood by the petitioner. The IO has done all in his powers to comply with the said notices, and therefore it cannot be said that there is inadequate compliance with the same. It is also pointed out by the learned additional PP that the age of the petitioner is a secondary factor, especially when such a large quantity of contraband in the nature of psychotropic substances have been recovered. I have perused the materials and considered the rival submissions. Full stop. In para 25 of Vihan Kumar, full stop, before going rival submission, in para 25, upon perusing the notices under 47 and 48, I find that they have reasonable details regarding the grounds of arrest, which is required to be provided to the petitioner, to the accused and his family member. However, undoubtedly, the notices and the grounds of arrest are in English language. Though as mentioned above, there is an endorsement of past recent, though there's an endorsement of having been, of these being explained to the accused in his own language. Full stop. The judgment referred to by the Honorable Apex Court in para 25 of Pravi Prokasta is the case of Lalu Bhai Jogi Bhai Patel versus Union of India, 1981 2 SCC 427. That judgment is in the context of Article 22(5) of the Constitution pertaining to preventive detention. The provisions of Article 22(5) may be reproduced herein below. However, the said provision pertaining to preventive detention also required the grounds of arrest to be communicated to the petitioner, to the accused, in a language that he understands. In the context of the said provision, para 20 Lalu Bhai, within brackets Supra, which has been referred to in para 25 of Pravi Prokasta, reads as follows. Do uthai dibo lagibo. Itu page of page number 2. 53, 77, 78, 278, 79. It has page 22 separately. SCC. Does the Honorable Apex Court think that if the grounds are only verbally explained and nothing in writing is left with him in a language that the detainee/accused understands, then the purpose would not be served and the constitutional mandate would still be infringed? Next paragraph. As already stated, though the aforesaid decision pertains to arose out of a preventive detention law, nevertheless, the principles therein, in my considered opinion, shall also be applicable to the accused, to an accused in a criminal case as well. Full stop. Therefore, the ratio that I determine from the aforesaid decision is that the investigating agency and the arresting authority will be held to high standards as far as communication of the grounds of arrest is concerned, not only in substance but also in form, to make the said constitutional rights meaningful. This court is bound by the mandate of law laid down by the Honorable Supreme Court to give effect to the spirit of the constitutional provisions enshrined in Article 22 of the Constitution. Full stop. Therefore, in such view of the matter, I come to the considered opinion that though the IO in this present case has traveled some distance in conveying the grounds of arrest to the petitioner, but nevertheless the same still fell short of in meeting the constitutional standards laid down by the Honorable Apex Court with regard to Pravi Prokasta and the earlier decision of Lokesh Lalu. Accordingly, in the aforesaid given facts and circumstances and the backdrop of the above discussion, I come to the considered opinion that the notices, despite having some details of grounds of arrest, still suffer from infirmity vis-a-vis the constitutional mandate, and thereby entitles the petitioner to be granted bail on the said grounds, as has been held in Pravi Prokasta and Bihan Kumar, Supra. Accordingly, the accused is hereby allowed to go on bail of rupees 80,000. Okay, 80,000 with one surety of the like amount, to the satisfaction of the concerned learned court, which is, it will be in one of the additional session judges, concerned learned court, not sure which session just called, concerned learned court at Kasar Silchar, and subject to the conditions that number one, he shall be available for trial if one commences. Number two, he shall not hamper or tamper with evidence. He shall not try to influence witnesses. He shall not in any manner indulge in any illegal activities, including activities violative of the NDPS Act. Instant bail petition stands allowed and disposed of on the aforesaid lines. Can I keep this?
Special judgment.
Yes, sir.
Kasar.
Yes, sir.
I'll give it back to you if you need it. Huh? Special judge?
Kasar Silchar. Lessons.
Whatever, just see, that's why I prefer to call the CD, because many of these components are actually non-necessary. Normal orders,
Yes,
sheets, not necessary actually. So we can have a trimmer case record. That's why I prefer only CD and charge sheet. Anyway. In Nagaland DGP told me that they have taken a lot of pains nowadays. In Nagaland DGP, he said that they have translated those grounds on all the 36 dialects, finding people who understand and then circulated to the SPs.
I did that one. So already might have dictated.
Yes.
Regarding 51, my lord, sorry, my lord, I have made one wrong submission, my lord, before your lordship.
Oh, very young victim. Huh?
Yes, my lord, 9 years.
Then it cannot be visible. Her statement is available.
She implicated, man.
Implicated.
You should have implicated because that is our contention, my lord, that because of this dispute, this FIR had been lodged.
Question answer format.
Yes, ma'am.
Really? Huh? Come on, it will be.
Though it's a matter of trial, my lord, so cannot submit on her veracity at this stage.
Section 10.
Section 10.
Section 10. It would be better to take the instructions.
Yes.
Take the instructions. Very tender age girl. So.
Main accused has already been released on bail on the very day of arrest, my lord. I have annexed the order, my lord. Lordship will find the order at page number 21. Offences under, my lord, the Assam Excise Act. Here I am neither the manufacturer nor the seller, my lord. Only I have given my land on rent to some person, and the land was situated far from my
And
home.
this record thing was carried out in that land.
In that land, my lord. In that land, my lord, at the very first, one water bottling plant was established, my lord.
Anyway, so
One chance, lord.
at this case, it will be prudent to see the case directly.
Yes.
No, I cannot give you any more relief. You are already on interim.
Yes.
My lord.
Otherwise, I could have considered that. Anyway, but
Friday, my lord, if possible, my lord.
3rd of November, lordship, Monday.
Third Friday also, I may be on half day leave because I have some work. So let it be the case diary, the learned counsel appearing for the excise department submits that he is taken over the matter today itself and seeks some time to procure the case diary. Mr. Khanikar, learned counsel.
My lord, RB Guha, my lord.
Oh, sorry, RB Guha, learned counsel. submits that though the petitioner is on interim bail, but case has been pending for the diary for a considerable time. Considerable time, I think.
My lord,
1621.
6 days, my lord, for
It's
saving.
considerable time. The case diary shall be procured by the next day, list on 311.
Look, oblige. Oblige, my lord. My lord, interim may be extended.
Interim bail granted by the order dated 27/6.
27/6, my lord.
27/6 stands extended till the next date of list.
High.
11. Yes, matter, no?
My lord, this matter, my lord, my learned senior
Oh, the
colleague. Mr.
taxation matter.
Yes, the Sutia, my lord, he has gone through, my lord. Mr. Bordhakur went there to call him, my lord.
Scan record is available.
Yes, Lord.
Yeah, because that will be
In a
necessary.
still copy.
That will be necessary.
কি গল? পালে নে? নাপালে। ক'ত বিচাৰিব লাগিব? মই আধাটা মাত পেলাই দৌৰিব লাগিব। এইটো কি লিখি থৈছে? একো সুন্দৰ কথা।
Prevention of cruelty to animals, some cattle preservation to Lagover.
Lordship, I have also annexed a copy of the prevention of cruelty to animals.
Okay.
That is in page number 23.
See, as you know, right, your learned counsel, you know that FIR can be quashed if on the face of it,
Yes.
you know.
Yes, Lordship.
If we, even if we accept no offenses made out, then it's a classic case. Bhajan Lal, one of the principles, right? Niharika infrastructure is there, it has come later, but that's the original principle in Bhajan Lal only. So that is why I first saw the FIR. You can make your submissions now.
Yes, Lordship, here what is happened is that the petitioner here is the registered owner of the truck. And moreover, the truck was stopped at a Naka checking at Koliabor. It is a 16-wheeler truck. It was carrying 30 numbers of oxens. So it was found here there and which was transferred from Dhemaji to Nagaon. But Lordship, in the FIR, the police have stated that it was, let me read out the FIR, Lordship.
Yeah.
I'll read the translated one because Lordship, I'm not familiar with the vernacular.
No.
With due respect, I'd like to inform you that today in 2/11/2023 during the wee hours at around so-and-so time, upon receipt of information from reliable sources, I along with the officer in charge of Koliabor Police Station and 3 numbers of VDV started Naka checking at NH 37, wherein we have stopped one 16-wheeler truck bearing registration number so-and-so. Upon being searched, we have found 30 numbers of ox which were kept in very pathetic condition without giving any water and food to them. The name of the said robber is Noor Islam Khan and son of so-and-so, resident of so-and-so, district so-and-so, and the name of the handyman is Dildar Hussain, son of so-and-so, and so-and-so. Upon being questioned to driver and handyman, they have confessed that the vehicle was loaded with a cattle from Silapathar, Dhemaji to be delivered at Meghalaya, and they were on transit at that point of time. However, they have failed to produce any proper receipt of the said cattle, and as such, we have seized the vehicle along with the cattle and have arrested the driver and the handyman. In view of the above, we suspect that the cattle are being transported illegally without giving them water and food. Therefore, the driver and the handyman are considered to be cattle thief and they might be involved in cow smuggling. And Lordship, page number 12 is the FIR, charge sheet from 13 onwards, which is the translated copy. The vernacular is in page number 18.
The present petitioner is Noor Islam.
No, my lord. Kamala Begum. She is the registered owner of that.
She is the owner of the truck.
Yes, Lordship. And moreover, Lordship, even the cattle were carried without the consent of the owner. And even the charge sheet, Lordship.
Did we see the charge sheet?
Yes.
Page 13.
Yes, page 13. It is here mentioned that in between And they admitted they were transporting the cattle from Golpara, Assam to Silab Bornihar of Meghalaya for illegal sale. It is the statement in the charge sheet, Lordship, which was submitted by the police, Lordship. But Lordship, no sane person in their right mind will bring a cattle from all the way from Golpara and go to Kolyabar and then come back to Bornihar, Lordship. And Lordship, even the cattle was given back, the Jimma was given of the truck and the cattle to the registered owners. It is recorded in the charge sheet itself, Your Lordship. And then the same is being on trial now, which is registered at PRC 10 of 2024.
Depositions not started.
No, Lordship.
Not started.
It is fixed for appearance. Lordship, and even the petitioner is ill. She had recently suffered a long illness and Lordship, for which she is not being able to present there.
That will be a little different matter anyway.
Yes, Lordship.
For the purpose of caution, right?
Yes, Lordship.
These Lollocs and trucks were produced before the Kamdhinu Gosala and they get Nogam.
Yes, Lordship. And even the Lord's,
It was involved in the case.
even in Lordship, if we come to page number 23, that is the prevention of cruelty to
Farm
animals.
owner from Kamala Begum and cattle owner. Yes, yes. What do you say?
My lord, may I take a leave from
just a
some moment, my lord? My learned colleague will, my lord.
You were saying something? What?
Yes, Lordship. The allegations against us is that just that the name of the RC belonging to the petitioner, the registration card, and then one Aadhaar card belonging to the petitioner was found in the truck, and including insurance and pollution under control cert. And Lordship, if your Lordship may come to page number 24, there is the section
Animal
11
cruelty.
of the prevention of cruelty to animals act. May I read it out, Lordship?
Just a minute. Which section has been given of Prevention of Cruelty Act?
11.
11. Okay.
Subsection A, beats, kicks, or overdrives, overloads, tortures, or otherwise treats any animal so as to subject to unnecessary pain or suffering, or causes, or being the owner permits any animal to be so treated. Or Lordship, I don't think it is possible to give water in a moving truck to the cattles. And moreover, Lordship, the truck is a 16-wheeler truck.
No, there is some provision,
Yes.
but I don't know exactly how it is
Yes.
done, but there are some provisions.
Or
But anyway, so
and Lordship,
employees and
Only, my lord, how many numbers of cars can, my lord, kettles can be carried, my lord, regarding that?
Lordship, is even there are few exemptions regarding page number 26, starting from page number 25, this is the copy of the Gazette notification issued by the government of Assam regarding the Assam Cattle Preservation Act of 2021. Section 4, Section 5, Section 6, Section 7. Section 7, which issues the prohibition of transport of cattle.
Section 6.
Section 7. And moreover, Lordship, a few sections are baseless because no slaughter was taken place. And even in slaughter, there are a few exemptions, which is on page number 32, section 19. This is the exemptions. Lordship, moreoverly, 19(1), clause C. Slaughter of cattle not being a cow or heifer or calf on such certain occasions as may be prescribed. Provided that in the case of a cattle belonging to the central government in the Ministry of Defense, certificate may be issued by a veterinary officer of the Indian Army. But Lordship, here no slaughter was taken place. Lordship, just it was being delivered to the registered owner of the cattle.
We see the sections again.
Lordship, IPC 120B, 379 and 411 has been added so far in the charge sheet.
120B.
Yes, sir. 120B, 379 and 411. Theft and dishonestly receiving stolen property.
120B, 379, 411. Stolen property. And then cruelty. And 13.1 is slaughter. 13.1
no,
is
there is-
slaughter. 13.1 of the Cattle Preservation Act is Assam Cattle Preservation Act.
My Lordship, that is the penalties under the section 4, 5, 6, 7 and 8. As provided under section 4, 5, 6, 7 and 8.
Just a minute. From Cattle Preservation Act, section 13. And animal cruelty is section 11.
Yes. 11.1 A, B, C, D. That should be on page number 24.
No, this we have already read, no? Employees overrides, overloads, tortures,
Yes, Lordship.
whoever, any person beats employees in infirmity. Hmm. What are the grounds you have given for quashing? Why it should be quashed?
Lordship, it is that the registered owner had no concern, the owner of the truck had no concern about cattle's being carried. And secondly, Lordship, it was being delivered to the owner of the cattle's.
The cattle has been returned back to the
Yes,
owner.
Lordship, it was in given Jimma by the learned CJM of Nagaon.
That order must be here, no? That order must
Yes,
be here.
Lordship, it is,
Must be in the case record.
it is recorded in the charge sheet, Your Lordship.
It's recorded in the charge.
Yes. If Your Lordship may kindly read the vernacular,
Disclosing the application.
that is in page number 18.
Prevention of the ingredients necessary to constitute an offense. Sorry.
That should be in page number 19, Lordship, first paragraph. Even they were given bail, Lords. Even the registered, even the owner of the cattle and the
Charge
owner
sheet,
of the.
where it is written, narrated in the charge sheet.
Yes, Lordship, page number 19.
Investigation to a truck and it says just whatever. Page number 13.
19. 13 is the translated, but 19 is the vernacular. I also have a certified copy if your Lordship may.
No, I did not find, where is it written that it was given Mung Logot Chorito and Podokyatota? It was given in Jimma, it was, I read, this much I've read, the blocks were placed in custody of Kamdhenu Gosala
Yes.
in Begenati, Nagaon for safekeeping, safekeeping.
Page number 19, first paragraph.
As per the court's directive, the seized road truck were handed over to the respective owners. Owner of the cattle is different.
Yes, Lordship.
Yeah, this petitioner is the owner of the truck.
Truck, yes.
Not the owner of the cattle.
The petitioner belongs to Barbeta and the owner is from Nagaon. And the truck driver and the handyman, they are from Sonitpur district.
Can I go to it? Yes.
Yes, my lord, although my lord, I have regarding that, I would just like to point out, my
No,
lord.
Boysa was wanting to say something, no? Did I interrupt him?
Yes, my
You
lord.
can,
Yes,
he wanted to make submission on this case.
yes, my lord.
Okay.
He is also, my lord, engaged in court
He's gone to
number.
another court.
Yes. My lord, regarding, I would just like to point out regarding the involvement of the petitioner, my lord, I will come later on, my lord, regarding that aspect, I will have to look into the TCR, my lord. Otherwise, regarding the present FIR, my lord, total, my lord, 13 numbers of, my lord, cattle were transported in that vehicle. Regard,
16 wheeler.
yes, in a prima facie, my lord, the manner how those, my lord, cattle were transported in the vehicle, my lord, prima facie, it seems that cruelty is attracted. Because, my lord, as per the how, my lord, your lordship, section 5 of the Assam Cattle Preservation Act 2021, the how those, my lord, cattle has to be transported in a particular vehicle, my lord, this is defined, my lord. And the cattle shall be transported in the manner prescribed by the central government.
Section?
Assam Cattle Preservation Act, my lord, I am just pointing out that prevention
Page
of cruelty
26.
to animals act 1960, my lord, is applicable. Page number 9, my lord.
This is number 9 of?
Assam Cattle Preservation Act 2021, my lord.
In the petition, it's 26, Lordship. And
What's your next? 26, yes.
Yes. The, my lord,
Section?
the,
5.
so Assam Cattle Preservation Act, section 7, subsection 5, my lord.
7.
The manner how the cattle has to be transported, my lord.
7, section 7.
Subsection 5, my lord.
Okay.
The cattle shall be transported in the manner prescribed by the central government rules governing the transport of cattle under the Prevention of Cruelty to Animals Act 1960, Central Act 59 of 60. But that act is now, my lord, not available. But as per my knowledge, in a, my lord, 16-wheeler vehicle also, well, maximum 8 numbers of cattle can be transported, my lord. Here in this, my lord, truck, total 30 numbers of, my lord, cattle were transported by the, my lord, whether regarding that owner is responsible or not. my lord.
The provision pertaining to the owner, I think it reads like that, that if the owner, he causes such animals to be transported.
Yes, ma'am.
Causes such animals to be taken.
Yes,
or
ma'am.
slaughtered.
Yes.
You know, that he is also responsible for it.
He is also then, if my lord, whether owner causes, my lord, these cattle to be transported, by my lord, as because he has the instruction for transporting all these kettles from a particular place to Borpeta, my lord, to the owner of the kettle, my lord, who is the owner of the kettle. So without his knowledge at this point of time from this FIR, my lord, that those kettles were loaded from a particular place, my lord, owner is from he submitted that owner is from a different place, and my lord, owner of the vehicle is from a different place, and kettle owner is from someone from Borpeta. So while loaded these kettles from a particular place, my lord, probably at that point of time it is difficult to say that owner of the vehicle, my lord, without his knowledge, all those kettles at that point of time only driver and handyman loaded those kettles in that truck, my lord. So to that aspect, my lord, to look into all these aspects, my lord, regarding the my lord, responsibility of the owner, because prima facie cruelty is there from the FIR, my lord. Because 30 numbers of kettle, my lord, they cannot transport, my lord, even in case of taking permission from the authority also, they cannot, my lord, transport it, use such a number of kettles in a vehicle in a
And let us see what are the materials collected during investigation to justify the charge sheet. Even if after the completion of investigation, the IO, from the point of view of prosecution, must have found some materials.
Some material
So
against
that is why he forwarded the owner also,
yes, yes.
who's seeking quash.
Yes, yes.
So we have to say what those materials are,
What those
and then apply our independent mind as to whether it is justified or not.
So, my lord,
Well,
to go into
I
that
think
aspect, my
I
lord.
found it. Copy of
Regarding specific materials against the present, my lord, vehicle owner. So, well, I will have to go through the records.
This is the case diary.
And my lord, in this, the lordship may come to the seizure list as well.
At page?
It starts from page 20. Page 20 is the money received of the Simon Chapri Delhi Weekly Market. And then page 21, where the registration number and belonging to the owner or petitioner, and then page number 22. This gives the description of seizures. One RC of truck number so and so in the name of Kamala Begum, and one insurance certificate issued by United Insurance Company Limited, and then one Aadhaar card in the name of Kamala Begum, who is the present petitioner. Moreover, lordship, the petitioner is a lady, housewife.
That will not be a very relevant factor, but he was trying to see what are the materials collected by investigation officer to submit the charge sheet. Right. No, he's saying Mukhtar Hussain, the owner of the truck. Customer Malik or Nam. The helper Dildar Hussain. Let me read it, then I'll give it to PP. Joakali interaction.
Animal to cruelty, 1960 conceived.
Yes, okay, it's not this.
Set up area.
23, 24.
Rule 56, Rule 56 to 9. Regarding transportation of Rule 56.
Yeah, both the driver and the helper are saying that the owner of the truck is Mukhtar Hussain.
No,
But
Lordship.
you said it's a lady,
The truck is registered in the name of Kamala Begum, wife of Mukhtar Hussain.
maybe.
Even in the charge sheet, it mentions that, Lordship. Even one RC was discovered in the same truck. In page number 22, Lordship, even the insurance certificate and Aadhaar card and RC, it belongs to Kamala Begum. Who happens to be the wife of Mukhtar Hussain.
The statement is incomplete. Can go to ভুল করলেন ঈশ্বর প্রাপ্তি বললে আবার Can you see this? Just kindly see this. The statement is incomplete. Something has been left behind. Yes. This. মাথা কি মনে Not incomplete, huh?
Yeah.
Not complete. Right?
Yes, ma'am. Yes, madam, not incomplete.
His statement was necessary.
Yes,
No,
probably, my lord.
it may be in some other part.
Yes, this,
Maybe in some other part of the same compilation.
same comparison, yes, madam.
They must have scanned it
Yes,
while typing. They might have mixed up
yes.
while stapling.
And my lord, I would just like to point out one thing from the, my lord, that regarding transportation of cattle, the number of cattle, my lord, regarding that can be transported in a vehicle is regulated under the Transport of Animal Rules 1978, framed under the Prevention of Cruelty to Animals Act 1960. Particularly under Chapter 4, my lord, Rule 47 to 46, which deals with transport of cattle. Rule 56, maximum number of cattle that may be transported. Well, I am just pointing out only regarding that is prima facie quel, regarding involvement of the owner, that is a different thing. Well, as per Rule 56 of the Transport of Animals Rule 1978 as amended, no goods vehicle shall carry more than 6 cattle including cows, bulls, bullocks, buffaloes, etc. at a time. In the case of smaller vehicles, the number must be, that is in respect of smaller vehicle, must be proportionally reduced depending on the space available.
Maximum is
Maximum is 6, my lord. In fact, in a 16-wheeler vehicle also, my lord.
6.
No goods vehicle shall carry more than 6 cattle, including cows, bulls, bullocks, buffaloes, etc.
Rule 47.
Yes, Rule 56, my lord. 56, starting from Rule 47 to 56. Adequate partitioning must be made within the vehicle to separate animals and prevent injury. Each animal must have sufficient floor space, ventilation, and be protected from direct sunlight and rain. So a valid certificate of fitness of transport issued by also.
Kindly see that Noor Islam's that statement, complete statement. Can you read out the FIR, sorry, the charge sheet narration one?
Yes.
Vernacular. Because he won't be able to, so.
Otherwise, my lord, driver, Noor Islam and the other apprehended helper, they named for the person, my lord, Muktab Hussain. Muktab Hussain is the, my lord, not the husband of the present petitioner, my lord. So police at the time of filing charge sheet, because she is the owner of the truck, so she named in the charge sheet, but left the, my lord, husband of the present petitioner, my lord.
Lordship, the petitioner has no involvement.
But on legally, she is the owner, right?
Yes.
So
May I read the charge sheet, my lord?
yes, there are 16. অভিযোগ
পত্ৰৰ সমূহ বিৱৰণী এই যে যোৱা ইংৰাজী 2-11-2023 তাৰিখে গোচৰীয়া NK কৃষ্ণকান্ত গগৈয়ে লিখিত এজাহাৰ দি জনায় যে ইংৰাজী 2-11-2023 পুৱতি নিশা 1:30 বজাত এক গোপন সূত্ৰৰ পম খেদি মাননীয় কলিয়াবৰ থানাৰ ভাৰপ্ৰাপ্ত বিষয়া মহোদয়ৰ লগত সংঘীয় ষ্টাফ ও দেহৰক্ষীৰ লোকসহ কলিয়াবৰ থানাৰ সন্মুখত 37 নং ৰাষ্ট্ৰীয় ঘাইপথত নাকা চেকিং কৰি A0NP so নম্বৰৰ 16 চকীয়া ট্ৰাক গাড়ীখন ৰখাই খানা তালাচী কৰাত ট্ৰাকখনত 30টা বলদ গৰু অতি নিৰ্মমভাৱে কোনো দানা পানী
যোগান
দানা পানী
যোগান
next
নধৰাকৈ
paragraph is not here, my lord. Then, my lord, বৰ্ণিহাটলৈ বিক্ৰী কৰাৰ উদ্দেশ্যে লৈ গৈ থকা বুলি কয় যদিও উক্ত গোধনসমূহৰ কোনো ধৰণৰ বৈধ নথিপত্ৰ দেখুৱাব নোৱাৰাত উক্ত বলদ গৰু আৰু ট্ৰাক গাড়ীখন 30 ট্ৰাকখনৰ পৰা উদ্ধাৰ কৰা সাক্ষীৰ সাক্ষাতত ভাৰপ্ৰাপ্ত ট্ৰাকখন 30 ট্ৰাকখনৰ পৰা উদ্ধাৰ কৰা সাক্ষীৰ সাক্ষাতত ভাৰপ্ৰাপ্ত বিষয়া মহোদয়ে জব্দনামা মতে জব্দ কৰে আৰু ট্ৰাকখনৰ চালক আৰু সহায়কক কৰায়ত্ব কৰে। উক্ত গৰুসমূহ ক'ৰবাৰ পৰা চুৰি কৰি অতি নিৰ্মমভাৱে কোনো দানা পানী যোগান নধৰাকৈ পদকীয়া দুজনে আৰু তেওঁলোকৰ আন আন সহযোগীৰ লগত চক্ৰান্ত কৰি অবৈধভাৱে বহিৰাজ্যত বিক্ৰী কৰিবলৈ লৈ যোৱা বুলি বিশ্বস্ত সূত্ৰৰ পৰা জানিব পৰা যায়। মতে জনোৱাত মোকৰ্দমা ৰুজু দি তদন্ত কৰা হয়। গোচৰৰ তদন্তকালত মোকৰ্দমাৰ ঘটনাস্থলী পৰিদৰ্শন কৰি ঘটনাস্থলীৰ মানচিত্ৰ অংকন কৰা হয়। গোচৰীয়া তথা সাক্ষীবাদীক সোধপোছ কৰি জবানবন্দী গ্ৰহণ কৰা হয়। ঘটনাৰ লগত জড়িত ট্ৰাক নম্বৰ খনৰ লগতে 30টা বলদ গৰু জব্দ নমামতে জব্দ কৰা হয়। মোকৰ্দমাৰ লগত জড়িত পদকীয়া গাড়ীখনৰ চালক নুৰ ইছলাম আৰু ট্ৰাকখনৰ খালাচী দিলদাৰ হুছেইন গ্ৰেপ্তাৰ কৰি ন্যায়িক জিম্মালৈ প্ৰেৰণ কৰা হয়। জব্দ কৰা 30টা বলদ গৰু আৰু ট্ৰাকখন মহামান্য আদালতত দেখুওৱা হয় আৰু গৰুকেইটা চোৱা চিতা কৰাৰ বাবে নগাঁৱৰ বেঙেনাটিত থকা কামধেনু গোশালাত জিম্মান দিয়া হয়। জব্দ কৰা গৰুকেইটা পশু ডাক্তৰ হতুৱাই স্বাস্থ্য পৰীক্ষা কৰাৰ লগতে পৰীক্ষাৰ প্ৰতিবেদন সংগ্ৰহ কৰা হয়। মোকৰ্দমাৰ লগত জড়িত আন পদকীয়া তথা ট্ৰাকখনৰ গৰাকী কমলা বেগম, স্বামী মুক্তাৰ হুছেইন আৰু জব্দ কৰা গৰুৰ গৰাকী আব্দুল ৰহমানক গ্ৰেপ্তাৰ কৰি মহামান্য আদালতৰ হুকুমমৰ্মে জামিনত দিয়া হয়। মহামান্য আদালতৰ হুকুমমৰ্মে জব্দ কৰা 30টা বলদ গৰু আৰু ট্ৰাকখন গৰাকীক জিম্মাত দিয়া হয়। তদন্তৰ শেষত মোকৰ্দমাটো গ্ৰেপ্তাৰী পদকীয়া নুৰ ইছলাম খান, দিলদাৰ হুছেইন, কমলা বেগম, আব্দুল ৰহমান, পিতা আব্দুল কাদিৰ the Hana Rupuhat under section of the Prevention of Cruelty Animal Act, read with section 13(1) of the Assam Cattle Preservation Act 2021 ধাৰাত সুপ্ৰতিষ্ঠিত হোৱাত তেওঁলোকৰ বিৰুদ্ধে মহামান্য আদালতত অভিযোগ পত্ৰ দাখিল কৰিলো। মহামান্য আদালতে তেওঁলোকক সমন যোগে মাতি বিচাৰ কৰাৰ প্ৰাৰ্থনা। But from the statement of the handyman, my helper and the driver regarding the present petitioner, only because she is the owner of the truck, so her name is my lord. Ultimately, my lord, she was search sheeted by the IO.
Yes.
But ultimately, the name of her husband was not sent up
On
for
the
trial.
statements of these witnesses, her
Husband
name of
was-
her husband is come.
Husband was not sent up for trial.
Husband was not sent.
Owner of the cattle was sent up for trial. Abdur Rahman.
Wakil may come once again to the charge sheet. It is written that it was written that they failed to produce any valid documents for the 30 auctions as well. But Lordship, even in the seizure list, documents were produced. This recorded in this seizure list.
This also I have noticed.
Yes, Lord. And
Sapori was weekly. Very much.
And Lordship, in charge sheet, it is written that they were traveling the cattle from Golpara to Bornihal. But Lordship, there is a different road.
5 members of white cattle heads, 5 members of red cattle heads, 5 members of members of black cattle heads, 5 members. That's 5 members. Total cattle 30. 1, 2, 3, 4, 5, 6, 7, 30. Okay, I'll reserve it then.
Yes, ma'am.
What can you do?
Right, your lordship may, my lord, regarding the, in respect of the present petitioner, my lord. So far as, my lord, the case, because this is admission stage. So far as, my lord, in respect of the present petitioner, may, your lordship may So regarding other accused persons.
No,
They are,
other, they are not,
they are not. the
only owner is
And
coming.
matter may be by staying the proceeding, at least only so far as it relates to the present petition, matter may be fixed for hearing, that can also be,
Hearing. Oh, in that case,
because my lord,
I
otherwise.
thought I'll have to dispose it of.
Oh, yes, well, I will leave, otherwise, my other accused persons will also, again, by provision.
Lordship may kindly consider an interim in that matter.
Only the present.
Only the present
Oh, yes.
petitioner is
This will be
contesting
seen
the
only
case.
from the point of view
So
of
far
the
as
present
it,
petitioner.
as it relates to the.
Present petitioner. But,
There are 4 persons involved, but only
I'm
the
finding
present petitioner
like-
is contesting.
I'm not finding it very easy because it depends her liability, whether owner, complicity, it can also be matter of trial. But on the basis of that trial will be conducted mostly on the basis of the statements recorded during investigation.
Yes.
And what has emerged against that person from these statements. Noor Islam, could you see, find the remaining statement?
No, my lord, remaining statement I have. not.
Nothing is yet so far
It's half,
against the petitioner.
only partial statement is available. That statement was necessary. That statement was necessary. Should be called for it.
Yes, my lord, your lordship may call.
Will it serve any purpose by calling for it?
Lordship may kindly consider an interim for a timing.
No, I was thinking of preserving it and disposing.
No, but first part of his statement, he has specifically, my lord,
Stated
stated
that-
that truck khনৰ মালিকৰ নাম মুক্তাব হুছেইন. So.
And your instruction of Omukot
Oh, yes, as per the.
that petrol
যোৱাকালি-
pump, and
yes.
then someone came and loaded
Yes,
his
yes.
cattle. That part is there.
যোৱাকালি ইংৰাজী 1/11/23 তাৰিখে মুক্তাব হুছেইনে মোক মোবাইল ফোনেৰে ফোন কৰি, মোবাইল নাম্বাৰ ইজ মেনশ্যন মেলৰ, গাড়ীখন চিলাপথাৰ পাৰ হৈ তেল ডিপু এটাত ৰৈ থাকিব দিছিল। মই আৰু মোৰ লগত থকা খালাচী দিলদাৰ হুছেইনে তাত যোৱাৰ পিছত এজন মানুহ আহি গাড়ীখনত গৰু উঠাই মেঘালয়ৰ লম্বু নামৰ ঠাইত লৈ যাবলৈ নিৰ্দেশ দিয়াত মই আহিছিলোঁ। মোক 26টা গৰু থকা বুলি কৈছিল। পিছত ৰাতি কলিয়াবৰ। So and otherwise the statement of the, my lord, handyman also, helper also, my lord, says almost similar, my lord, regarding
What might have happened is that in this case that she is owner in name.
name.
Yes. Main it is run by the husband. So these cows were
By-
probably not stolen.
Yes.
They were purchased from market and
They were being transferred from
they,
point A to
were,
point
they
B.
wanted to transport it to Meghalaya. Suppose.
Vehicle
And
is,
they were carrying the cattle in large numbers
yes,
beyond the permissible
Yes.
capacity.
yes.
So because otherwise receipts wouldn't have been there if it was stolen.
By using the name
But the
of the
question is
petition.
whether the owner can be held liable, the paper owner.
Yes, otherwise difficult is that, my lord, by using the name of her husband, wife, my lord, the petitioner, my main accused person is the husband of the
Husband is-
petitioner. He is, my lord, doing all these businesses well involved. My lord, surprisingly, my lord, IO has not sent up him for trial, my lord.
Lordship, I want to point a few stuffs. The first thing is that,
Then should I keep it reserved, part third?
Yes.
yes, your lordship,
No, you tell me, we have some 5 minutes.
just a few stuffs. I
My
like.
lord,
to point
otherwise,
out.
from the materials available on record, my lord, your lordship can also dispose it of, my lord. I will leave it to your lordship.
Now it will not be possible to
No,
dictate.
today not possible, my lord. Your lordship may otherwise fix some other day, my lord.
Within this week.
I will have to
if
again.
possible.
No, you submit. You
Firstly,
make your
Lord-
point.
Lordship, firstly, receipt was given from the cement Chapuri Delhi market,
Hmm.
which was to be delivered to the owner of the cattle.
Hmm.
And secondly, it was not supposed to be transported to Bornihat, but it was supposed to be transported to Nogao. By the way, which is a fact. And since even the learned CJM had taken the matter into consideration, and then after that only, the learned CJM has granted Jimma to the registered owner of the cattle. Even we have to take that point into consideration, Lordship. Otherwise, so far only the drug would have been given Jimma. Even the cattle were given back Jimma, even after it was submitted to the veterinary.
So unlikely that they were stolen. But these two things are there.
Yes.
Transported to Meghalaya outside the state, violating that provision.
Yes.
That you have to have a permit
Permit.
to transport it within Assam to outside the state, where slaughtering is not regulated.
Yes.
So that violate 13(7), I think, 7(1).
Yes.
7(1). And secondly, loading.
Loading, my lord, the prima facie,
things
my
are
lord,
there.
cruelty is there.
These two offences might be made out, but whether against the lady.
Lady, my lord. That is the, my lord.
If we take a liberal view, then it can be
Difficulty is that,
cautious.
my lord, by using the name of the
cautious.
lady, my lord, by, my lord, that her husband is.
Your
involved with-
point is also right, actually, that
That is the difficulty, my lord. In
the
most
court
of the
should
offences, my
may
lord,
invoke 319 later on, anyway.
Lordship may kindly fix a date for.
Should I, you want some more arguments or should I close it? No, if you want something to be said, then I will keep it. Otherwise, I will make it savvy.
Your Lordship may proceed.
Should I?
Yes.
Doimari, no? Mr.
Yes,
Mr.
Lord.
Doimari Learned Counsel addresses his arguments. Full stop on the matter seeking quashing of the FIR and charge sheet by the petitioner who stated to be the owner of the truck which was allegedly carrying cattle in violation of law. The also heard the learned additional people by the state. The case record, scanned case record has been received. Full stop. Arguments concluded, judgment is reserved.
and some of the points which my learned friend he has raised, my lord, that during trial, everything will become that.
We can see it like that also, that if that aspect is a matter, if we see it as a tribal issue, then no case for quashing. But
Yes,
if
yes.
we, on the basis
Otherwise,
of existing materials, if
otherwise
we think that
everyone-
the materials are insufficient against the owner, then it is a case for quashing.
Otherwise, my lord, everyone who is involved in committing this type of offences, they never, my lord, registered the vehicle in their
Their name.
own name. my lord.
Lordship, there is a high chance of acquittal. Even during the charge hearing, almost more than half of the sections will be removed as well.
My lord, charge not yet friend, my lord, at that
Trial,
point.
trial is yet
He,
started.
he-
It
he
is
can,
fit
my
for
lord,
appearance,
he
Your
can
Lordship.
urge all these points at the time of framing of charge, my lord. He can be discharged at that point of time also, my lord.
Actually. Your rest remaining matters you have to mention.
Yes.
Item number 46. The I is a pending, 389 application is pending.
Item 36.
46, my lord,
Just a bit. 46.
46.
Inter orders thank you. No?
And prosecution
It's
was,
of work actually, so otherwise.
prosecution was supposed to file their objection.
For 46.
46, but for
Okay.
last 3 months, it has not yet been filed.
You find an objection.
Ma'am, let it come up on Thursday. In the meantime, they will file. Because 3 months have gone, my lord, for, they have taken time for filing the objection.
Find the objection. Let it be on Monday. Monday or Tuesday. Monday or Tuesday. Paucity of time, 46 leave option. Paucity of time.
Third.
On my lord,
Yeah.
6 or 7.
Prosecution, the case is at the stage of filing of objection, if any, by the prosecution. Stop. It is submitted by the, no, like that. The prosecution may file its objection, if any, for the next date, fixed on 7/11.
But let it be on 6, 7, it may not reach, my lord. Let it be on 6, the hearing date.
No, my lord, on 6th I'll be out of session. I'm appearing for response.
7/11.
Take-
Reaching is a big problem, no doubt. 7 also, 6 also. 6 or 7?
Can it be on?
7. Huh?
Okay, my lord.
So,
Okay.
then next.
Item number 45, Lordship.
Mhm.
Lordship, as per the office note dated 23/10/25, neither ID card nor answer notice was received back, Lordship. But the postal tracking consignment report is, so that's already the notice is served, Lordship, upon the respondent number 2.
File to like put it on.
It was served on 18th of August 2025, Lordship. Probably
Or
request
passed on next date. Nowadays too, this doesn't come. AD doesn't come now. Nothing. You have to consignment number.
I have collected from the section.
That GPO.
Lordship.
Where is it delivered? Shown?
Sir, Lordship, in the first page, Lordship.
Original pin code and delivery location.
Item delivered.
In the status.
The current status, item delivered on August 18, 2025 at 5:32 PM.
Consignment.
Lordship. Lordship, even in the second page, Lordship, Serial number 13, top Lordship.
No,
Item
po-
delivered.
Postal consignment of the, do you have the postal receipts? No, no?
No Lordship.
Because we have to just tally with this, no?
May not be interested in.
LCR has been received,
Lordship.
has been received. no?
25.
Scan,
Scan copy was called for Lordship, which was already received. Lordship.
scan record has been received.
Lordship.
Uh, But with regard to service, the petitioner side is submitted postal tracking pertaining to consignment number RS 60187114, sorry, 6018711844 in, which is stated to have been delivered on 18th August 25 at 5:32 PM. The letter, no? So, prosecution, so we have to cross check, no, this one. I'm just taking our guidance. Because I used to, just, to try. I'm not disbelieving, of course, I believe you. But usually, I'm not, of course, I believe you. But this must have been served, but we used to check this number with that receipt number. Receipt number is not there, we don't have the receipt number. You can submit it before the registry, actually. And registry can verify that can be done.
Consignment number is there, Lord. Consignment number is there.
Consignment number, Lordship.
Consignment
RS.
number From here only.
Yes, Lord. For the tracking. Which the registry can verify.
Registry can verify. The registry will verify the postal tracking and submit put up a note.
Lordship, interim order passed,
Regarding
that may be
service.
continuing.
Interim order asked shall continue till the next date of this.
Lordship, a date may be fixed. Lordship.
Leave the matter on after 3 weeks.
Can it be 2 weeks, Lordship?
Oh, jammed, just wait since you have interim. 1711. 1711. Then
Lordship, in item
48.
item 48, Lordship, there is a typographical error in the impugn order, Lordship. A typographical error in the impugn order,
Oh.
Lordship. At page number 8, relevant person at page number 9.
The I has been filed for correcting a typographical error in order dated 26/9/25 passed by this court in criminal petition number 842 of 2025. This is disposed of.
In para 2 and para 3, Lordship.
What is the error?
Lordship, in PRC case number, paragraph 2, Lordship, 4th line, PRC case number 1602 has written instead of 2602.
Oh, in which paragraph of the order?
Para 2 and para 3, Lordship.
So in para 2 and 3, the PRC number has been typed incorrectly. And it should be PRC number
2602.
2602 instead of PRC 1602.
2602 of 2019.
Then instead of 1602 of 2019. And this typographic error stands corrected, and this order shall be read as part of the order dated 26/9/2025, passed in criminal petition 842 of 25. The IS stands disposed of. This kind of matters you can upgrade. This kind of matters is justified to be upgraded because it's not your mistake, right? It's my mistake. So our mistake. So it is my duty to correct it at the earliest so that you can get the benefit of the order. This kind of matters be justified to be upgraded, not all matters certainly. Anyway,